to the rat house, baby, where the truth ain't quiet, and neither are you. Where the CHATRATS crew slide in, pull up a seat, crime talk, cold facts, and a jazzy backbeat. We got stories to tell, got some justice to serve, so pour up that coffee or something with a swerve. There's Rat Daddy leading 6'5", a cool Toys the queen with the sharpest of tools. Dean's cracking jokes, Mary B's got the tea, and Lawleen lays the law down, real boss energy. MJ's got the fire, Gingy's taking names, Cassie's dropping Angel Baby's in the game. The clerk's keeping order, Misty's watching close. Pinky promises, keeps receipts, and she does the most. We're the CHATRATS, baby, worldwide and bold. Stories unfold while the crime scene gets cold. Puff, puff, pass, and the truth gets exposed. At the rat house, baby, that's how it goes. Snap, snap. Cherry lights it up. Sherry lights it up, neon glow behind her head. Tombstones drops the facts that awake the dead. Connor's taking notes, Janine's on the clock. Hetty the paralegal keeps the court on lock. Sweet woman, sweet, but she'll sting if you like. Calypso keeps it cool, got that island vibe. Prince Lover's in purple, that Texas pride glowing. Sherry's laughing loud while the facts keep flowing. Bum, 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 bum. Da-da-bum, da-da-bum, ghetto. OG coming through, crazy-eyed cheese, oh you better believe. Robo-rat clicks, sparks, gears in his head, breaking the code till the lies drop dead. Jump, feel confident, jump. We're the CHATRATS, baby, worldwide and bold. Stories unfold while the crime scene gets cold. Puff, puff, pass, and the truth gets exposed. At the rat house, baby, that's how it goes. Crime solving, cracks. World's our stage. That's a fact. Together, we're the CHATRATS crew. We ain't looking back.
What's up, everybody? Welcome back to another episode of What the. I'm Danny Thomas, and this is Rat House Media, whatever that is. Mary B, whoever you are.
What's up, folks?
What up? What you up to?
Oh, you know, just getting settled back in at home.
Oh.
Now I can stay at my own house. It's lovely.
Oh, the dog sitting is over with?
Yep, they're back. The dog was very upset to see me leave this morning. In fact, the neighbors told my sister that he was barking aggressively at me. He doesn't like when people leave.
Oh, yeah. That's weird.
Yeah, it's very weird. But that's his thing. My cats don't do that.
No, they don't care if you leave or not.
They're like, whatever, leave food for us.
Stay in my food bowl. Stay out of my stuff.
Yep.
Stay out of my stuff.
There was no collision.
But I really don't have a whole lot to do, but then it hit me what I'd like to do. What would be
Ooh.
for all of us to start with. How about Alan Jackson's closing statements?
Oh, I love that.
That's good stuff. I mean,
But both trials or just the newest one?
let's just do the newest one.
Oh,
Maybe
okay.
compare the two.
Yeah, I think that would be fun.
Maybe we'll play the first one second and the second one first.
Sounds great. What's the bus trial, Angel Baby? Do you know that one?
Mm-mm.
Oh,
Is
she'll
that
have
the
to.
alley and alley where they were fighting at the bus stop?
Oh, right. We did watch that.
Oh yeah, Lally testified today, but I don't. The young jerks would be the only place to get that. Let's see.
Well, they were streaming at a bunch of places. The Young Jerks is best though, because he doesn't like say stuff and pause and stuff. I didn't get to see much of it, but I heard that the lawyer that's questioning him is a badass. So I am looking forward to watching that as well. Finishing up on True Crime Tarot stream. Where's that? True Crime Tarot. That sounds like a good idea. You're muted.
Yeah, they were going in and out. Sorry. Where's the True Crime Tarot? Because I know Toya been all up in that, all up in there, doing it. What's up, sweet woman?
Hey,
Oh, you know, just pressing buttons. What's going on?
chilling.
Gingy missed the whole stream last night.
Gee.
Whole stream on purpose. Gingy. And the weird thing, Jesus, man, these shorts are killing it on subscribers. That makes 11 today.
Yeah, you're gonna like just drop us on
Nice.
that.
I know. But I want to show you something else, though, since I can show you stuff on here. Let's see. Yeah, we're up to 113.
Nice.
And last night's live stream has 270 views.
All right. See, they're getting back up there.
Doesn't seem like a big deal, but we've been at 120. Two of them went to 160. And as soon as
Yeah.
we got 100 subscribers, we started getting a troll. And then we got a few people out of the algorithm. And now all of a sudden, we got a rewatch crew kicking. So we're almost at 300 views on last night.
Oh yeah, I forgot to keep commenting on the replay. I'll have to remember to do that.
As you can see. But the shorts are just, I didn't know this last time. What a dummy.
It's like TikTok wannabe.
Yeah, I got 3,000 views today on 3 little 30-second videos.
Yeah.
Would you say you're up to 30?
3,000 today.
Oh, 3,000. Nice.
Yeah. In the last 10 or 12 days, I'm almost to 25,000 views. 25,000 views on these shorts. Pretty cool. It's gotten us almost 20 subscribers off of them things, too.
Yeah, people like the building shit.
I guess so. I guess so.
They might be stopping into the lives thinking it's like going to be live building shit, and it's not, and they're disappointed.
Just us talking.
I think
Sorry.
but I'm telling you, the faster, it's going to go faster and faster.
Yeah, it takes off exponentially.
I don't know about exponentially, but you add it up mathematically, it would be considered faster and faster. It's not going to be 1,000 anything in one day.
You never know.
But those little shorts are helping us build our little pirate signal.
Who knows? Maybe you'll be at a concert and you'll see a guy cheating on his wife, and you'll take a video of it and you'll post it up, and the next thing you know,
Nice.
I saw
That
that.
could be my mission for the rest of the summer.
Yes.
Try to catch the inconspicuous people hiding in the corner.
Mm-hmm. Something sketchy's definitely going on. Make sure you get that on video.
Definitely. Imagine what that original video's gotten as far as views.
Yeah, there was that. He was on like a YouTube channel or something.
Oh yeah, if you're smart, when you do it, post it on your YouTube channel and make it everybody watch it from there.
Yeah, exactly.
Yeah. So we'll have to stop this frequently. I hate playing other people's streams. But
Yeah.
commentary will work. Commentary works.
I like commenting on shit.
Oh, Ginger's been sick. Oh, that sucks. You wasn't sick
No.
at yesterday. Where were we all at? Everywhere?
Yeah,
Yep.
that's the only acceptable excuse is being sick.
Mhm. Yeah. No excuses, because you're the one that has to go to the other lives and find the people that are cheating on us.
Right. Exactly. We were looking
Oh,
for
that's
you.
right.
We were going into the other lives.
There was some infidelity last night, wasn't there?
Yeah, Ginger's the
Yeah.
bounty.
Because Turtle Boy was on Melanie Little forever.
Yeah. It's gonna be. Yeah. All right, here we go.
From
Lally.
state police.
Lally.
I think it would vary. I think there were certainly items that I probably had to ask for more than once, but there were definitely items that I had asked for and was provided promptly, and then moved on from there to either additional information or that avenue was complete.
So do you keep records of, I asked for search warrants, I asked for crime lab stuff, I asked for witness statements. Do you keep records when you receive that information to be able to check off to say, I got these things, they're no longer outstanding and the rest of this is?
I mean, I keep records in the sense of a list of items I'm looking for. And obviously when I receive something, then yeah, that would get checked off the list as far as I'm not looking for that anymore because I have it.
Okay. So if you got a set of grand jury minutes from a witness that you know testified in front of the grand jury, you'd check that off your list.
Well, as far as yes, I mean, I was at the grand jury, so I know who testified at the grand jury. But as far as receiving the minutes, yes, I'm aware of the dates. And when I received the minutes, then that would.
I don't know the person's name, Angel, but he's been in jail for a long time, and they haven't started his trial or done his hearings or produced evidence. Sweet woman knows more about it than I do.
So unlike him.
Yeah.
Yeah, his last name is King, I believe.
Wow,
Yes.
that's a lot of information.
This is King. But anyways, they haven't given him a speedy trial. And this is
Exactly.
they're grilling Lally on why he hasn't had a speedy trial.
Mm-hmm. We know why.
That would check that off the list.
I missed, I think, a question and answer, one question earlier. I think the question was, do you keep records of what you requested? What was your answer to that question?
So records, as far as what was requested, I would always have, at least in some form, some sort of running list of items I was looking for. And then if I received an item, then that would be something that would be off the list. Now that list would be obviously added to as information develops, and there might be additional items that I'm looking for.
And presumably because it's on the list, you've made the request?
Yes.
Okay.
And so you'd have whatever's on the list, you'd have emails requesting that information. Is that right?
Yes.
Okay. And then if they emailed back, you'd have checks off of your list that you got whatever it was. That, you know, maybe you were asking for 10 things and you got 5. You'd check those 5 things off your list. Is that right?
Yes.
Is there any other mechanism you used to document what you got from, just right now we're talking about the state police, Trooper Tully and Trooper Proctor?
I'm sorry, any other mechanism of doing what again?
Keeping track of what they're producing for you. Is it all just emails and check marks on a list? Or is there some other way that you keep track as well?
No, I mean, it would be something that I would have a list of items that are outstanding that would be, you know, followed up on if they hadn't been received at that point, and then I would follow up with whoever the appropriate person was to get copies of those.
And these lists remain in the file? Your lists with the check marks remain in the file?
To the best of my knowledge, yes.
Okay. And have you reviewed any of them before you testified here today?
No,
Okay. Is there a reason you didn't review the file before you testified here today?
I don't have the file.
You work for the DA's office, right?
I do.
Do your homework.
It's in the DA's office, right?
Yes.
And you knew you were going to be.
He just didn't read it.
He's like, prepare? Why would I do that?
It's so embarrassing.
Like, ma'am, we're not supposed to do that stuff.
I didn't know I was supposed to read it.
But he knew who was at the grand jury. I was there.
Yeah, he didn't need to write it down.
Yeah, I have a list and I check it off when it's done. It's like, no, you don't. You don't have a fucking list.
Crazy
You don't
guy.
give a shit.
He's a wild and crazy guy.
Ask questions about this case, right?
Yes.
And you didn't do anything to educate yourself about what you did initially on the case?
Objection. This is her witness.
Well, I'm not sure I agree with that as an objection, but I'm going to sustain the objection as to the relevance. He did not review the file. Next
So
question.
what did you review in preparation for your testimony here today?
I reviewed portions of the file. I reviewed some of the items that have been produced by ADA Hickman. I reviewed search warrants. I reviewed police reports. I reviewed, you were asking me specifically as far as checklists or notations. I didn't review those, but I did review, I have portions of the file. I have access to the file, and I did review portions of the file.
Okay. So you did review the first portions of the files?
Yes. Oh, yes.
You just didn't review your checklist?
No.
Okay. Now, in terms of the Milton Police Department, do you also have emails going back and forth to the Milton Police Department asking for certain documents?
Yes.
And who in the police, would that be Lieutenant Collins?
Yes.
Anyone else in the Milton Police Department were you looking for documents from?
On this case, I don't believe so, no.
And did you keep the same type of list that you kept for the state police of outstanding things that you were looking for the Milton Police Department?
Yes.
And what did you get back from the Milton Police Department? Do you remember?
Items of similar nature that they had access to as far as police reports, photographs. I don't believe Milton did any of the search warrants in this case, but other items of discovery, video that they recovered, that there's a litany of different items.
A litany of different items?
Yes.
Okay. And those would all be memorialized by email? Is that how you did it?
Yes, that's, I think, what Mr. McGee attached as Exhibit 1. It's about 137 pages.
Of emails back and forth between the Milton Police Department and you?
Correct.
And so at what point do you know that you have all of, so other than, strike that, Milton Police, State Police, any other person or entity that you sought information for in this case?
Certainly.
I'm sorry?
Yes.
Who's that?
Be the Office of the Chief Medical Examiner, be the State Police Crime Lab. There were some items that were outsourced to Bodie Technology Lab in Lorton, Virginia, where they did some additional forensic testing pursuant to DNA. They have different methods that our lab does not. Milton Fire Department, I believe Fallon paramedics were involved in the transport of the victim, Mr. Simmons. That's all I can think of at this point.
Okay. And would you communicate with those agencies the same way you communicated with the State Police and the Milton Police via email?
For the most part, could have been a phone call on some of those
All right, so let's stop there. If there was a phone call, how did you memorialize what you requested and what they said in a phone call?
Notes.
You have individual notes?
Yes.
And where would those notes be right now?
In the file.
Okay. So do you keep like a running page of all the notes that you've taken in the case with communications that you had with all of the other entities and officers in State Police in this case?
Not all in one location, but it would be sort of divided up by different entities as far as what I was requesting from that specific entity and what I was looking for, what I was still waiting for, what was still outstanding, things of that nature. Okay.
So what happens when you ask for something, let's just say from the State Police, and they don't give it to you? What's the next thing you do?
The next thing I do would be to ask for it again.
Okay. How many times do you ask for it before you have a meeting with the State Police to look at their file?
Objection. The biggest objection I have here is that we're not speaking about any individual document, any individual date. Vague questions about
Yeah, this is general practice, generally Mr. Lally's practice. I think part of the issue here is we don't have very specific items that are being referred to.
Right.
But I think I'm going to overrule the objection and give Attorney Scapiccio a little bit of leeway here in terms of general practice.
So in general, how many times do you email for the same document before you go to the state police and start to have a sit down with them?
I think it varies. I think it would be depending on a lot of different factors as far as what the item is, what the explanation is for why I don't have it yet, whether it's not available or whether it's something that they're currently working on, or if it's something that I know has been completed. And I've asked for it multiple times and I still don't have it. I'm not saying that even happened in this case, but if in a general practice, if that were something that were going on, then yes, I would want to sit down with somebody and figure out exactly what's going on.
Okay. So let me ask specific questions about this case. When you reached out, let's start with Trooper Proctor. In this case, looking for information, and there were emails back and forth. Were there any occasions where you did not get the documents or the information that you were seeking from Trooper Proctor?
I don't recall anything specific other than if it was a situation where I'm looking for a report about something and that report hasn't been completed yet, or that item hasn't been obtained yet for whatever reason. But I don't recall in this case ever asking for something and just not getting it.
Do you remember asking Trooper Proctor for the search warrants that he did in this case?
Yes.
And the affidavits accompanying the search warrants?
Yes.
And did he provide them to you?
What I received was a partial affidavit for search warrant.
Did he provide them to you, yes or no?
Some.
How many search warrants do you recall there being in the King Gardner case?
In 2021 or beyond?
Let's start with 2021. How many search warrants? You guys have search warrants?
6.
6. Did he, when you asked, and he signed all 6 search warrants, is that fair to say?
That's my understanding, yes.
Okay. And so when did you ask Trooper Proctor for the search warrants?
In July or August of 2021 when they were filed for.
Okay. And when did you get all 6 search warrants from Trooper Proctor?
I didn't get all 6 search warrants from Trooper Proctor.
You did not?
I did not.
Okay. So did you get 1 search warrant from him?
From him specifically, I received a portion of the affidavit for search warrant 306 and the entire affidavit for search warrant 348.
Okay, so you got portions of 2 search warrants, and you knew there were 6 search warrants, is that right?
Yes.
Did you make notes somewhere in your file? Geez, I asked Trooper Proctor for these 6 search warrants. He hasn't given them to me yet?
I believe, yes.
Okay, those notes are in your file?
I believe so, yes.
Okay. And then when you didn't get the search warrants from Trooper Proctor, did you meet with him?
Yes, I mean, specific to that, I don't recall any specific meeting related to search warrants, but we did meet several times in relation to this investigation in this case.
But you understand that search warrants are Rule 14 automatic discovery, right? And you knew there were 6 search warrants, right?
I did.
And so when do you realize that you don't have all 6 search warrants? How long into the process? Do you know right away you don't have them all? Or do you not know for a long time you don't have them all?
I don't think I realized at that time that I didn't have them all.
So I guess I'm confused about how your system works. You said you had a system where if you asked for something and you didn't get it, you would then follow up with the police officer asking again and again. Did you do that with Trooper Proctor in this case with the 6 search warrants?
Yes, I believe so.
How many times did you email Trooper Proctor asking for the 6 search warrants?
I don't know.
More than 10?
I don't believe so, no.
Okay. How far in between each email? Did you wait a month and email him again? Did you wait a week? Did you wait a day? How long in between your requests to Trooper Proctor to produce the 6 search warrants in this case?
I don't know.
You don't?
No.
Did you review your emails before you came here today?
Some of them, yes.
Did you see any emails to and from Trooper Proctor regarding the search warrants?
Yes.
How many did you see?
I don't recall.
More than 5?
Yes.
More than 10?
I don't know.
What are the dates of the first time you asked Trooper Proctor for the search warrant?
Specific date, I don't know.
How long before the next time you asked him for a 6 search warrant?
Specifically, I don't know.
Was it months or weeks?
Weeks.
Weeks later. Okay,
Yes.
so that's 2 times you asked him. What about the third time? How much time went by?
I don't know.
Months or weeks?
I don't know.
What about the fourth time?
Again, I don't know how many times, and I don't know specific dates.
So I guess
That's
my question
amazing.
is, how does your system work if you're not getting the discovery that you're asking a police officer for, and you're asked for it, let's just say 5 times?
What did you say, sweet one?
This is like gold to me. Like this makes me so happy.
Your system doesn't seem to be working. I love her.
Yeah. She's getting after his ass, that's for sure.
That's great.
Yeah. He's definitely squirming. I wish we had a better view of him. So we could
I
see
know.
this.
What do? Do you go to the office and you sit down and say, give me these search warrants, I have to turn them over?
Yes.
You did?
Yes.
Did you do that this case?
Yes.
You go to Trooper Proctor and say, give me the search warrants because I have to turn them over.
Yes.
When did you do that?
Sometime prior to the defendant's arraignment in December of 21.
November of 21, did you say?
December of 21.
December of 21. So when you get to his office, do you go there or do you tell him to come to your office? I don't know how that works.
Either way, I don't
Remember
remember.
how you met about the search warrants the first time?
The,
In other words, did he come to you or you go to him?
I don't know.
Okay. So you have a sit down
Yes.
and you ask him for the 6 search warrants. And what does he say?
He will get them to me.
He will get them to you.
Yes.
Okay. If you tell him I have an obligation to turn this over because it's Rule 14 discovery, I need it right away, I've asked for it 5 times, what's the deal?
Those specific words, no, but the gist, yes.
Well, tell me what you said specifically.
I don't know.
Well, give me a best estimate of what you said to Trooper Proctor after you asked 5 times
Objection.
search warrants that he didn't turn over.
Sustained.
So did you keep any notes of your conversations with Trooper Proctor when you were asking for these 6 search warrants that he didn't give you?
No.
Why not?
It was something that I knew that was outstanding. It was something that I had asked for in written form numerous times. I didn't feel the need to write a note that I asked for it again.
So that's the first sit down. Did you send emails after the first sit down saying, hey, you promised me you're going to send these 6 search warrants, I still don't have them?
Objection, assuming facts.
Overruled.
I'm sorry, could you repeat the
Did you
question?
send another email to Trooper Proctor after you had the sit down at sometime in December of 2021 saying, hey, you still didn't send those 6 search warrants, can you send them over?
Yes.
How far after Mr. King's arraignment in December of 2021 did you send that email to Trooper Proctor?
I don't know.
Was it a year?
I don't think so, no.
What do you think? What's your best estimate of when you sent that email after you sat down with Trooper Proctor?
I would say probably a few months later.
All right, a few months.
Yes.
So February, March of 2022, is that what you're thinking?
I don't recall specifically.
So when you're in this room with Trooper Proctor asking about the 6 search warrants, do you ask him for his file? Like, give me your whole file so I can go through it and figure out what's in it?
No.
Why not? You're there. There's outstanding discovery. You have the obligation, not the police officer. Why don't you ask?
I entrusted that whatever discovery I was requesting, I would get at some point in a timely fashion and then turn it over.
But you didn't get it. You asked for it 5 times. You didn't get it. You had to go see him. You have them right there now, and you still don't say, give me your file? Let me go through it?
No, I did not.
And when he says you'll get the search warrants, I'll send them to you. Did he have them? Did he have copies of the search warrants? He just wasn't giving them to you?
That I don't know. You'd have to ask him.
Well, you don't get the search warrants in any event after that sit down, and you send another email What's Trooper Proctor's response to that email?
Again, I don't know that I sent another email, but I know that there were subsequent conversations about it. Whether it was what format it was in, I don't know.
Okay, and at this point, you have to be getting a little upset with Trooper Proctor that you're asking for information he's not giving you, right?
Objection.
Overruled.
I'm sorry, your question again?
You have to be getting a little upset at Trooper Proctor that you're asking him for information that he's not giving you, right?
I'd say upset, frustrated probably.
I'm sorry?
Frustrated probably.
Judge, will you approach sidebar just briefly? I know.
Sure.
Judge is like, do I have to?
He's overruling everything.
Yeah, he's like, no, I want to hear this.
So basically, they were sitting on all this discovery, and that's what this is about. Like, part of this was I believe oh, help me out, guys. A motion to dismiss.
It doesn't seem like they like giving stuff in general.
Doesn't seem like what?
Is that what you're saying?
What's that?
Question.
No, saying it doesn't seem like they love giving up discovery.
No, seriously. Like, I'm waiting for Lally to be like, I was busy persecuting Karen Reed to follow up on this guy's case.
In any event, ADA Lally, a couple of months goes by, you still don't have it.
Yeah. We were too busy framing this other chick. I forgot all about this guy. Sorry. And they'll be like, okay, you'll be fine. Just get it handled.
6 search warrant.
Okay, that's fair.
What do you do?
I don't know. I mean, I specific to the 6 search warrants, I don't recall as far as there was a topic that was discussed repeatedly. Obviously, I never received them because I never provided them to you or to Ms. Costa.
Okay. So I guess what I'm saying is you knew they existed and you knew that, let me just say this, you knew that all six search warrants existed. Is that right?
Yes, we went through all six of the search warrants on the last day of the grand jury presentation on November 19th, 2021. That's in the grand jury minutes as far as going through each of the materials, each of the search warrants, that they were search warrants, how that material was obtained, and the material that was returned in response to 3 of the search warrants was marked as grand jury exhibits 33, 34, and 35.
Right, but not the search warrant.
Correct. Well, no, actually, I'm sorry.
Information in front of the grand jury about 6 search warrants that you hadn't seen, and you put returns or information that had been returned in front of the grand jury on search warrants you had never seen.
So with
Answer that question.
and I'm trying to. So
Okay.
with regard to those 3 search warrants, that was 306, 307, and 329, which were the call detail records for your client, the victim, Mr. Simmons, and Mr. Jeanette. The materials that came back from the cell phone providers also contained a copy of the warrant, as well as the addendum to the warrant, which was then also provided to you and Ms. Costa in discovery.
But not the warrants themselves.
No, the warrants themselves and the addendums, not the application and not the affidavit.
Right, so you understand that in order to make a determination as to whether or not you're going to suppress certain information, you actually need what you asked for and what you, in the affidavit that told the clerk magistrate why you had probable cause, right?
Objection.
I can take judicial notice of that, and I'm sure Mr. Lally knows that.
Okay, so you get in front of the grand jury. When do you present this case to the grand jury?
Began in July of 2021. That grand jury sat in July, August, and September. The presentation had not been completed at that point, so there was a motion to extend the grand jury. And I believe there was one subsequent date that we went before them on November 19th, 2021.
November what?
19th, 2021, that's when indictments were returned.
In 2021?
Correct.
Okay. So at some point when Mr. King is arraigned, you understand at that point, Rule 14 kicks in, right?
Yes, I mean, I'm thinking about Rule 14 well before that.
Okay. And you know, when you arraign Mr. King, you still don't have the search warrant. You have another conversation with Trooper Proctor about, hey, where are these search warrants? I have to turn them over.
I'm sure I did.
And do you know when that would have been?
I don't.
Okay. And then, remember at some point in December of 2021, receiving a discovery notice from me. Hey, First Witness,
Yes.
this is just my discovery notice.
That discovery motion, or what is
Motion,
that?
I'm sorry, motion, Judge.
Yes.
Okay. And do you remember, after having filed this motion, you asked the time to go through and make sure that you can comply with all the requests, right?
Yes.
You didn't have any specific objections to anything that I was asking for, right?
At that time, no.
Okay. May I First Witness, Your Honor?
Yes.
Sorry, Judge.
Is that an exhibit? Is that a docket entry?
It is a docket entry, Judge.
Do you know what it is?
I think it
Or we can mark that just so that there's a record of what you're showing the witness?
has my writing on it, Judge. So
All right,
I won't
so-
mark it. But I'll do it after the hearing. I'll find the exhibit and I'll make a clean copy and send it to the court, Judge. So once you get the discovery notice, you know for sure that there are certain categories of information that we're looking for, right?
Yes.
And number one is all automatic mandatory discovery under Rule 14, right?
Correct.
Would you consider those search warrants automatic mandatory discovery under Rule 14? Okay. And we were looking for any and all statements of witnesses, is that right?
Yes.
And we were looking for all exculpatory information, whether
The
tangible.
document speaks for itself.
Okay, that's fine, Judge. So after I filed this motion to December of 2021, you have another conversation with Trooper Proctor saying, give me the 6 search warrants.
I'm sure I did. My general practice is if there is any discovery motion that's filed by counsel, what I'll do is I'll send that to the appropriate police personnel as far as making requests and making sure that they're apprised of what's been at least asked for.
Excuse me. And did you do that in this case? Did you send my motion for discovery to Trooper Proctor, to the Milton Police, to the crime lab, to the medical examiner's office? Did you send it to all of those entities?
Every motion that you filed, yes.
Okay. And then what do you do to follow up with each of those entities? Let's start with the state police. They get a copy of my discovery motion. You're looking for all of the evidence that they have, and specifically these 6 search warrants that, for whatever reason, Trooper Proctor hasn't given you. When you follow up, how long does it take you to follow up from the time that you give them the motion until?
My guess, 3.5 years. What's your guess, Mary B?
I would say about that, if ever.
If ever. That's a good guess, too. What do you think, Sweet One? What's your time frame on reply? I mean, like you said, the guy's definitely guilty, but damn. And Proctor's involved. Shit, there's an opening right there.
Yeah.
Guilty will be going free.
Anything Proctor's involved, shit could be crumbling. Especially something like this. It's,
Yep.
obviously, you don't want to go digging into all of those documents because you're going to find a bunch of fucking errors, I'm sure. I just still don't get all the intentional and misspelled words in these officers' reports. What is that shit?
I don't know. I think we're giving them too much credit for like thinking they're intentional. I think they're just dumb.
That's what I'm really beginning to think.
Like they're literally stupid.
It's too common. It's too common. That many people can't misspell that many fucking words.
Weren't there people like misspelling their own names?
Yeah. Spelling your own fucking name? No.
Yeah, definitely a special kind of idiot.
Janine.
Yo,
That was like in harmony.
Hi, Janine.
Hey, sweet woman. Hey, Mary B. Hey, brother.
What's up,
going
girl?
on? Oh, is this Larry? We're watching you, Larry. Yay.
It's so fun.
We got
Like, I
Alex.
love his heavy size.
It's like a guilty pleasure, right? It's like comfort food now that it's like it's not ours to deal with.
100%.
Ay, ay, ay. How
So
far
we got
into it?
Alan Jackson's closing statement after this from the second trial.
Oh, okay. Okay, gotcha.
Unless you want to watch Hankies.
Oh yeah, I definitely want to hear that voice again.
Chalkboard. Prince
No,
Level!
thank you. We're gonna kick this up a little bit.
Hey,
I do like watching Lally squirm, but I can't really see him. So
Yeah.
I could be squirming or what?
So wait, so this is from today you're watching, right?
Yeah.
We're just
Lally in
watching
the hot seat. And then after this, so how far in are you?
about 25 minutes.
Oh, okay.
We're about 40 minutes in on the stream, so I don't know what the fuck we did for 20 minutes.
Like
Time flies.
greetings and stuff.
We lost some time. I don't know what we did with it. You got it, Mary B? You got my 20 minutes?
Yeah, we were just chatting, shooting the breeze.
We're doing a little drift. Like it's pretty fun.
Mm-hmm.
Mm-hmm.
Get any,
Specifically, I don't know. Typically, I would give it a couple of weeks or so.
and after a couple, and in this case, did you give it a couple of weeks, you think?
Probably.
Okay. And then what happens?
And then I'll follow up again.
When you say follow up, do you send another email or do you get in your car and drive down there and say, we got to end this, give me the stuff?
I would email or a phone call.
Okay. And so did you email or phone call, or make a phone call to Trooper Proctor in this case?
I'm sure I did.
And what was his response?
I don't
When you
recall.
asked for the 6 search warrants?
I don't recall.
Well, do you have any notes of your conversation with him? Remember you taking notes?
I don't believe so, no.
Is there a reason that you didn't take notes when you spoke to Trooper Proctor after these search warrants had become an issue? That you wouldn't take notes of what Trooper Proctor told you about the search warrants?
So you're asking me about a conversation that I don't recall specifically when it happened or exactly what was said. So whether or not I took notes for that conversation, I don't know. What I would do typically in my general practice is to follow up with whoever I had outstanding discovery requests in relation to try to get whatever information that I was seeking.
Okay, and so did you follow up with Trooper Proctor about the 6 search warrants?
I'm sure I did, amongst probably a number of other items.
Okay, and then you knew the case was going in for another date on discovery, right?
Yes.
And you knew you'd have to answer to the court what you've provided and what's outstanding. Isn't that typically how it goes on discovery dates?
Yes.
Did you ever tell the court, geez, I got having 6 search warrants that Trooper Proctor has, I can't get my hands on them, can you issue an order or can you help me out here?
Did I do that? No.
So when you went to court, do you remember representing to the court that discovery was ongoing and that you were producing as much information as you could? Remember that?
Typically, that's what I would say if that was the case, yes.
Okay, but you knew when you represented that to the court that you didn't have the search warrants, right?
Yes.
So what was your plan? How are you going to get them?
As I stated, what my practice would be if there was some outstanding item of discovery, I would request it and follow up if I hadn't received it.
But you did that. You requested it 5 times. You went to see him. Then you got my discovery motion. You sent that to him. You waited another month. And then what happened?
I don't recall.
Well, don't you tell him, get me these things now. I'm coming down your office.
Objection.
Overruled.
Did I ever tell him that? No.
Okay. So what do you do when he's not complying with your request? What's the policy in the office of the district attorney's office in Norfolk County when a state trooper is not complying with a request for discovery?
Objection.
Uh-oh.
Sorry.
That's
Was
okay,
that a loaded question? Why are you not responding to our request?
I didn't know if we were taking bets on what the answer was.
She said Norfolk County. So why did you even ask that question?
Right?
You answered the question right at the end with the words Norfolk County.
The-
But you know, these lawyers have watched all this Karen Reed shit, and they know who's dirty now. They're gonna start picking on them like buzzards.
Yep.
Yeah.
Roger's gonna go through the ringer about 30 times, probably. Hopefully,
Comma.
karma's a bitch.
There
It'll
you
get
go.
Overruled if there is a policy.
What's the policy?
I don't know any specific policy related to that.
So do you go to your supervisor's hand and say, hey, I've asked Trooper Proctor 5, 6, 7 times for these search warrants. I've been down to see him in person at least once. He's not giving them to me. What do I do?
No.
Did you ever have another case other than Mr. King and Ms. Gardner's case where a state trooper didn't give you search warrants that you had been asking for since before indictment?
Objection. Overruled.
Not that I recall, no.
Okay.
Your Honor, may I be heard on one slight issue? The discovery that the discovery request that counsel is speaking to, I don't believe that it was ever docketed. I don't have a copy of it. I've never seen it. So
The motion. The motion.
Motion for discovery was filed. He got
it may not have reached the docket. Like
I want to make sure that you see it, though. Let's make sure you.
I'm speaking about it a lot here. And
No, no.
I've never seen it.
Attorney Scapiccio, can you just give it to Mr. McGee for a second?
Sure. You think it would be in the file?
I would think it would be in the file. Is that a clean copy?
That is a clean copy, Judge.
Can we mark that? Should we mark it?
It's unsigned, and it's probably, I don't know if it's a draft or
Oh, the non-signed, all right, so let me get you a signed copy, Judge.
I don't know what was.
The bottom line is, this witness said he received it, Judge. I know I wouldn't have not filed it. We talked about it in the hearing. And I think there is a transcript, Judge, of a hearing where we talked about the discovery motion, the court had it.
All right, we'll figure that out.
You got it?
We do have ADA Hickman did have a copy.
You do have a copy.
I never saw it on the docket. I was working right off the docket.
Okay.
So,
And just so the record is clear, we have marked it. Do you want it marked as Exhibit 1 in this hearing?
yes, sir.
Sure.
All right.
Get you a signed copy, Carol.
All right. That will be Exhibit 1.
Thank you. I'd also, at some point, Judge, like to mark the pretrial conference report, in this case.
Thank you.
So this had never happened to you before, Attorney Riley, and you didn't go to Lynn Beelan, who was your supervisor, and ask her what to do. What was your plan? How were you going to solve it?
I don't recall specifically having a plan. If there was a situation where I was asking a trooper or a case officer for something and I had not yet received it, I might get that person's supervisor involved as far as saying, I've asked for this a few times, I don't have it.
Okay, let's stop there. Trooper Tully was Trooper Proctor's supervisor, is that right?
Yes.
Did you go to Trooper Tully and say, hey, I don't know what the deal is, but I can't get these 6 search warrants from Trooper Proctor. Can you have him send them to me?
Specifically about the search warrants, I don't recall.
You didn't go to a supervisor.
I don't know if I did or I didn't.
But as you sit here today, you don't remember going to a supervisor, is that right?
I know that there were a number of meetings in relation to discovery that Lieutenant Tully was present for, along with Trooper Proctor, but going specifically to his office to demand 6 search warrants, I don't recall that.
Okay. So how much time goes by before you ask for the search warrants again?
I don't know.
Is it a year?
I don't know.
During the time period, you got to say that we were appearing in court every couple of months on discovery, right?
Yes.
You don't know.
Did you ever notify the court on any of those court appearances that you were having trouble getting custody of the 6 search warrants that were issued in this case?
No.
Okay. Now, you talked about having meetings, discovery meetings. Tell us what those are.
At various points, probably more towards the early stages, or if there's something that's significant that comes up, it would be just a meeting in relation to, this is the discovery that's outstanding, this is what I'm looking for, what's the ETA on this, when should I expect to receive this?
And are those meetings in person or on the phone?
Typically in person.
And do they take place at the DA's office or at the state police?
Well, I mean, in this specific instance, the state police is attached to the DA's office, so it's the same building. So whether it was my end of the hall or their end of the hall, I don't know.
Okay. And do you remember discussing the search warrants and the outstanding nature of the search warrants at the first discovery meeting?
Yes.
And what was the response?
That the search warrants are still ongoing, as some of those search warrants were not just July. I believe it continued into probably September of 2021 as far as the last of the search warrants. I could be off on those dates, but.
So how many motions or how many meetings do you have regarding discovery before the return of the search warrant in July of 2021, if that's the date?
Not many. I mean, that's the murder occurs on July 10th, so there's not a lot of time in between that. So probably 2 at the most.
2, okay. And you don't take any notes on those meetings either?
I don't know.
But I guess I can't figure out, how do you keep track? If you have this list that says all these things are outstanding and you're having these meetings because there's things outstanding, if you're not taking notes at these meetings, how do you know what people are saying and when to expect to discuss it?
No, if there was something that specifically was known as far as, this is what's going on with this piece, and an anticipated sort of ETA on return or something, then yeah, there would probably be a note about that.
All right, so let's assume that the returns came back the latest July of 2021. Let's give you 3 months, August, September, October. October of 2021. Are you asking again for the search warrant? So you still don't
We've been over this time period. I'm trying to figure out you went all the way through arraignment and on the number of meetings and emails back and forth. I get it, but maybe you want to cover new ground.
I'm just trying to figure out, let me ask a question. So when do you realize that you never turned over the search warrant? When do you realize that?
As far as the 2021?
When do you get the search warrant in your custody?
In my custody?
Yeah.
I would say probably I became aware of it about a month ago.
In 2025?
Yes.
July of 2025 or June of 2025?
Yes.
Is the first time you became aware that you didn't turn over the search warrant?
Yes, if I had been aware earlier, then I would have turned over the search warrants.
But you had your list, right? You had your list that said 6 search warrants outstanding, right?
Yes.
You didn't ever check that off, right?
No.
So you knew they were outstanding, right?
Yes.
Okay. And then when did they get to your file?
Again, so as far as my file, they did not. Again, I became aware of it after the case had been transferred from myself to ADA Hickman.
Well, let's talk about that. What date was the case transferred from you to ADA Hickman?
I'd say probably somewhere in October or November of 2024.
2024?
Yes.
And how does the case, let me just say in general, how does the case get transferred from one DA to another? Is there a policy within the Norfolk County District Attorney's Office of what needs to get done to transfer a file?
No policy, no.
Okay. So what did you do in this case with Mr. King and Mr. Gardner to ensure that your complete file got in the hands of ADA Hickman?
So I physically took the physical file from my office to ADA Hickman's office.
Okay. Did you have a conversation with her?
Yes.
And did you tell her, hey, there's 6 search warrants that I was never able to get from Cooper Proctor?
Again, if I had known or remembered that the 6 search warrants were still outstanding, then I would have got them and provided them. So no, I did not reference that specifically.
But then at some point, ADA Hickman has to come back to you and say, did you not turn over these 6 search warrants? Say that to you?
No.
She never did?
Nope.
Did you ever have a conversation with ADA Hickman about the outstanding 6 search warrants?
Not until recently, no.
Okay, and what transpired?
Objection. Sustained.
Well, so when you told the court that discovery was almost complete, did you know when you made that representation that the 6 search warrants were still outstanding?
Objection.
I don't know what time frame we're talking about.
I also, as I've stated in my opposition, I've reviewed the FDRs on this from December and February and the other dates in 2025. That statement was never made. So, and then December.
That's why I want a date.
And October as well, when Your Honor set this for trial. So thank you.
So when's the last time you remember answering on this case?
I believe it was December of 2024.
Could it have been January of 2024?
January 2024?
Oh, so let me back it up. In January 2024, were you still representing the Commonwealth?
Yes.
Okay. And do you remember there being a hearing regarding discovery?
Not specifically, but I'm sure there were.
And do you remember, excuse me, do you remember the court asking about discovery and how the discovery was proceeding?
I'm sure it happened. I don't recall that specific date or what was asked.
Okay. And do you remember telling the court in January 2024 that you were hopeful that by March of 2024, we could proceed forward because discovery would be complete? Remember that?
I don't.
Okay. May I approach this time?
Yes.
Oh, hell. Y'all see who that is?
Mary Whitcomb! It's so good to see you.
Oh my
It's been
God!
so long.
Where have you been? We missed you, Mary. Hey.
I feel like we were just talking about her. We summoned her.
That
Yes,
was
we
me.
have been asking. Yeah.
Well, I said I hadn't seen her in Tom's in order to guilt her into showing up.
Aw,
Found her this morning.
Good to see you. And
so
little
nice
Miss Red
to meet you.
Velvet. Here.
Hugs.
Everybody's been asking about where the hugs are.
That's
Yeah.
right. We missed
No
your
one's getting
hug.
hugs lately.
Little Miss and Mary Whitcomb are here.
Little Miss is here. Yay!
Hey, little miss.
Hey, little Miss, little Miss.
Yeah, Mary passing out them hugs. Everybody's been missing them hugs.
And Calypso. Yay!
Calypso, what's up?
What's going on?
Hey, Calypso.
Our friends are here. Yay. Tombstones. Little Miss, Mary, Calypso.
Seriously, you don't get this on any other channel.
That's right. Leva,
don't know.
Angel, Clerk, Gingy, Cheryl,
Clue who you are.
all the players.
Yeah. Who was that laugh remind me of?
Fine.
Who is it, sweet woman? Misty.
It's on the tip of my tongue. Who is it?
Oh, it's yeah, I got it. Masuka.
Masuka!
Yes, that's Janine's laugh. Janine and Masuka laugh like each other.
Yeah.
Luca, is that a good thing?
All right.
I
Hold on.
accept. Misty's here.
Yeah.
Yay.
Hey, Misty.
It's a party now. All our friends are here.
Yeah, they should be here all the time.
So who's
Yeah.
Masuka?
I'm gonna
There you
find
go.
it.
Hanging. That's okay. I'll look it up.
Can you hear that?
Do I hear what?
No.
No. I
That's
hear
weird. These headphones,
my
I can hear,
washing machine.
I
It's
can
a
hear the extra videos, but you can't. So that's cool.
Ooh.
Wrong sale. Okay, I found it. This. I hope we don't get in trouble. This is Janine's laugh.
Masuka's the coolest.
Oh yeah.
Aw, thank you, I guess.
Little Masuka. All right. This Lally thing is really boring.
I
Is it not?
appreciate that.
Oh, I think it's so like gratifying.
It is, but it's
Oh my God, it is.
we're halfway through it.
This is decadent.
It's
So good.
full speed ahead.
That's it.
But maybe
January 2024.
Show you the request.
May I first withdraw?
Yes.
Going to give you the transcript of the appearance before this board on January 24, 2024. Now you look at page 5. And tell me, read that bottom page 5 to yourself and the top of page 6.
Hey, Don Marie.
Dawn Marie has like almost 800 subscribers. So
Don
Damn.
Wow.
your
Oh,
channel
yeah,
is-
I think I knew that. Yes.
Proud. Angela can probably find it, but Dawn's probably got it at the ready. So drop it in the chat.
Yes, please. I don't know if I'm subbed up, but I'd love to.
She goes live too.
Oh, cool.
We might watch one day.
Nice.
By one day, I mean 2 days.
Yep.
We might do it.
Yeah.
Does that refresh your memory as to whether or not in January 2024 you told this court that substantial discovery was complete? There might be 1 or 2 items that are outstanding, but we get into it.
I didn't read that portion. I was reading the highlighted portion. If I could have a moment. I'm sorry, I'm not seeing what you're referring to in that.
Well, do you remember telling the court, Your Honor, I think as far as discovery goes, we're in a fairly good position. Did you say that to the court?
I may have.
Look at lines 16, 17, and 18 on the document that's in front of you, Ms. Lally.
And what page, Mr.
Page
Chapter?
4, line 16, 17.
This Weasley bastard said I may have. I may have. It's not sure. I might have said that.
17 and 18. The court asks, where are we, Ms. ADA Lally? And you say, Your Honor, I think as far as discovery goes, we're in a fairly good position. Did you say that?
Again, I'm sorry, in the transcript that you handed me, I don't see that.
Let me see, it's a different one.
Sped up, it sounded like he said a transcript that you handed me. Rat bastard.
Do you remember? Hold on, let me get this right. Do you remember telling the court, oh, you're wrong, you were right. Do you remember telling the court there may be a couple of outstanding pieces talking about discovery that I'll check on, and some other pieces that I was speaking to Mr. Coster about, but I think hopefully that by March 11th date, we should be able to proceed forward. Remember saying that to the court?
Do I remember saying that to the court? No. If
Does reading that refresh your memory that you said it to the court?
I didn't read that portion. What page are we on?
Yes.
You can read from here over to here. Yourself, please.
Sure. Yes, that's correct.
Does that refresh your memory? Video rally that you indicated to the court that, that's right. There may be a couple of outstanding pieces that I'll check on, and some other pieces that I was speaking to Ms. Coster about, and hopefully by the March 11th date, we should be able to proceed forward. Did you say that to the court?
Well, those are two. So does it refresh my memory? No, but according to that transcript, that's what I said. Yes.
Okay. And you know at that point that there were still 6 outstanding search warrants that you didn't have?
No. Again, if I had known, then I would have gotten them and provided them.
Okay. But weren't we talking about search warrants on this day?
You're talking about 2022 search warrants, which were in a subsequent notice of discovery related to a cell tower dump. You were provided all of those as far as the application, the affidavit, the return, and copies of the warrants themselves.
So we're talking about search warrants.
Separate search warrants, yes.
And nothing's ringing a bell that you didn't turn over 6 search warrants?
Apparently not.
Okay. So the 2022 search warrants that we talked about in court back on January 24th of 2024. At that point, Mr. King was indicted. Is that right?
Yes.
Was Ms. Gardner indicted?
Yes.
All right. So what process did you go?
Look, Danny, Lisa Eyeball is here.
Lisa Eyeball. Oh my
Yeah.
God.
Lisa Eyeball.
Lisa
Mary
has-
hasn't seen her rat yet.
Mary Whitcomb does have a rat. I think Toy definitely made you one. So.
Yeah, I've seen her.
Where is Pinky Promises? She must be lurking.
Who?
Sometimes she lurks. Pinky, you know, Pinky
Oh,
Promises.
Pinky Promises. Yeah. Yeah, she'll be in, hopefully.
Which I say that, but we stream 5 times a damn week. You know what I mean? So it could only be 3 days.
She'll be
Through
here.
to issue the 2022 search warrants.
3 days is a long time.
Mm-hmm.
Now it is. This is Janine and fucking Teddy and Toys fault. That's who I'm blaming.
What for what?
And
What I-
Lois. I wish Lois was here so I could blame her.
Oh my God. Yes. We need Lois back. We need, you know what we need to do? Old school summoning. We need to summon Lois and Petty. Well, Petty's, yeah.
She's been camping for a while. I think she might have went to Camp Crystal Lake. I think they made a mistake.
No, that's the worst camp of all. She ain't come back from that one, brother.
Yeah, her and JDD got out there goofing off, and top came off. And you know, in them 80s movies, when Jason sees them tops come off, he can't handle it.
Oh, Lord.
Yeah.
No.
The tickets were cheap to Crystal Lake. You know what I mean?
Jesus.
You could stay for a week for $30. Yeah.
And then that Mrs.
You know, you can bring
Voorhees. Woof.
Well, you usually get one good night of cooking out at Crystal Lake
Yeah.
before you run for your life.
After indictment.
Through this court.
And they use
Sorry?
the
Through the
flag
court.
practice.
You went to Superior Court.
Yeah, whoever's fastest wins that game.
Yeah.
Like running from a bear.
Mm-hmm.
Yeah, just be faster than the guy next to you. You'll be fine.
and asked for these search warrants. Is that right?
Myself personally, no.
Well, did you notify defense counsel that you were asking for search warrants in a case where a client had already been indicted?
No.
Do you know whether or not there's an obligation on behalf of the district attorney's office to notify defense counsel post-indictment if you're moving to request additional search warrants?
They weren't search warrants that were pertaining to the defendants. They were.
Did you know whether or not there is an obligation on behalf of the district attorney's office, you specifically, to notify defense counsel if you're seeking search warrants after indictment?
Objection. If this is a legal, yeah.
Sustained.
Thank you.
So in any event, we're talking about search warrants in January of 2024. You don't say anything about the search warrants that are still outstanding, those 6. And you tell the court there's only a few things that are outstanding then. Is that right?
Yes.
Okay. And then we come back. We suggest March, and we come back in March. Is that right?
I believe so, yes.
Okay. Then in March, do you tell the court, Your Honor, as far as discovery goes, we're in fairly good position. In regard to that, I believe that was turned over just prior at the last date. So there may be a couple of other additional items of discovery that I need to get and turn over. But otherwise, I think we're in a fairly good position. Did you say that to the court, sir?
Again, I don't know.
Your Honor.
Yes. These transcripts in the FDR, what's on the FDR, what was said by whom, when, is all a matter of public record, and we can look at the FDR and get it. So specific quotes and what was said, what was represented, that's part of the record, and we can see
I just have to set it up so I can ask the question that I want to ask, Judge.
Great.
Thank you. So after having made that representation to the court, did you do anything to get the 6 search warrants?
No.
What were the outstanding matters as far as you understood back in March of 2024?
I don't recall exactly what we were talking about on a court date in March of 2024.
Do you have any notes that would refresh your memory as to what was outstanding at that point?
I might.
And would they be in your file?
If they were anywhere, that's where they would be, yes.
Okay. Now, other than the discovery motion that we filed, did we also file a pretrial conference report in this case?
That I don't recall.
Okay. But you understand, normally we file a pretrial conference report where you agree to give you what I'm asking for, and we agree to file motions on stuff we can't agree on. Is that typically how it goes?
Yes.
Okay. And you don't remember signing a pretrial conference report? Not that you didn't, you just don't recall.
I don't recall every pretrial conference report I signed.
Okay. And then we talked about the meeting with the state police. Did you have any meetings with the Milton police regarding outstanding discovery?
In-person meetings? No.
Did you send the Milton police the same type of discovery request that you would have sent to the state police?
Yes.
And did you follow up with the Milton police the same way that you say you followed up with the state police?
Yes.
And did you follow up specifically with Lieutenant Collins?
Yes.
And so what in your mind was outstanding on the Milton discovery that you were communicating with Lieutenant Collins regarding?
At what time?
Let's start at the beginning.
Again, it's the same type of information that you asked about before, as far as reports or photographs or any material that they might have pertinent to the case.
So whatever the Milton police turned over to you, would you have kept notes of that somewhere?
Yes.
Or there's been emails back and forth between you and Milton about what transpired?
Yes.
Okay. Did you have any trouble getting information from the Milton Police Department?
No.
When you asked for things, did they return your email and give you what you were looking for?
Yes.
Were there any reports from the Milton Police Department that you say you didn't have before you turned the case over to ADA Hickman?
There was one report, yes.
And what was that report regarding?
Mr. Turner.
I'm sorry?
Mr. Turner.
And what about Mr. Turner?
There was a report in the materials that ADA Hickman turned over in 2025 that was, I believe, offered by Detective Sergeant Clifford Murphy pertaining to Mr. Turner that I had never seen before.
Okay. And do you know why that wasn't turned over by the Milton Police Department?
No.
Did you go down to the Milton Police Department and look through their files?
No.
At any point in time when you were representing the Commonwealth, in this case, did you go down to the Milton Police Department and look through their files?
No.
Is that something that you would normally do in a homicide case? Go to the police officer's office and ask for the files?
At what point in the case?
At any point.
Typically, that would be something that I would endeavor to do closer to trial.
Closer to trial?
Yes.
So how could you make sure your obligation was satisfied if you're not meeting with the police until right before trial?
It's an ongoing duty and obligation that extends even beyond the trial.
Right, that's not my point. My point is if you're not meeting with them and you're not going through their information, how do you know you've turned everything over to the defense?
Because I requested it and I've been given assurances or information indicating that that is what they have.
Let me ask you the same question about the state police. Did you ever go through the state police file while you were handling the case, as opposed to making requests and even sitting down with the state police to make, face-to-face requests on an ongoing basis and all the follow-up contacts that you had? Did you ever actually request their whole file to go through it yourself?
No.
Okay.
And can you tell us, was there a policy within the Norfolk County District Attorney's Office of sitting down with police departments, whether it's state police or Milton Police, and reviewing their file prior to trial?
Not that I'm aware of, no.
Okay. So how far in advance of trial do you finally sit down and go through, let's take the Milton Police box?
It would depend case to case, but it's something that I would probably do at least a few months ahead of trial.
A few months. And is that the first time that you put your hands on the actual box, or are you still dependent upon the Lieutenant Collins and other officers to give you what you're looking for?
Oh, that would be a time where I'm actually like, let me see the file and ensure that I have everything that you have.
Okay. And is there any prohibition to that meeting that you have a couple of months prior to trial happening right after indictment?
No, and that would be my practice now. So you're asking about sort of my general practice at the time. That would have been it at the time, but now I would do that much, much earlier in the case.
Okay. And the state police the same way? You said, did you sit down with them at some point and look through their file, or you never looked through their file?
No, as His Honor just asked, no, I didn't.
Okay. So I guess my question is, how did it work? Did they only look through their file and send you what you're asking for? Or did it, at any point did they send you, here, here's everything that we have?
My request and my ask was for everything they had. So as far as me then double checking to ensure that I have everything they have, that would be something that would occur later on. And as I just indicated, my practice now would be to do that much earlier in the case.
Okay. So when you go in this case, you knew we had picked a September 8th trial date, right?
I was aware, yes.
Okay. So you knew the case was ready for trial September 8th. When were you planning on sitting down with the Milton police and going through their file?
As the case was reassigned to ADA Hickman around the time that we selected the trial date, I don't know that I had a specific plan to do that. I did have a specific plan to meet with ADA Hickman to go through the file to ensure that she had everything that was there.
So when by the time she had taken over in January of 2025, you had not made any plans to sit down with the Milton police to go through their file, is that right?
She had taken over prior to that, but no, I hadn't.
Okay, and the same with the state police, is that right?
Correct.
Okay, so when you're updating ADA Hickman, when she takes over the case, do you tell her, I've never actually seen the files, it's on my list of things to do, but I never get down there, you should get out and take over the files?
Not that specific, but yes.
What did you tell her?
That, during the regular trial preparation or meeting with the officers as it gets closer to trial, I would do that, but I hadn't done that yet.
So I'm still trying to understand, is there like when the police give you something, do they just email it to you, or is there like a list to say, we gave ADA Lally these documents on this date?
As far as their list?
Yes.
I have no idea what they have.
Okay. Because you don't know, as I today, if they have an index of all the things they say they gave to you.
I don't.
Okay. And do you, on the opposite side, have an index of the things you got from them?
It would be contained within those requests, yes.
All right, so at some point, do you print out all your requests and say, okay, let me just make sure I have everything here. I've been requesting something since, December of 2021. I want to make sure I have everything. Do you sit down and do that at some point to make sure everything you requested, you received?
My general practice would be, yes, that would be as I know we're getting closer to a trial date.
Attorney Scapiccio, it's a little after 11, and we're going to be able to go until about 11:10. And then I have to break because we're going to have to do the motions to suppress on the two other matters. So we need to think about an appropriate time to break. Maybe now is a good time to break, and we need to talk about another date when we can come back and continue the hearing.
Sure.
Okay. Attorney Lally, you can step down. Thank you. For the record, I think the defendant's general motion for relevant discovery is docket number 8 in docket number 21, CR 320. That's what we were going to mark as Exhibit 1. It's signed by you, Ms. Scapiccio.
It was on behalf of Ms. Gardner.
I don't know. I didn't dig up a motion to join, but in any event, we're talking about what would be otherwise Exhibit 1. It's docket number 8 in the case. All right. Next dates. I would like to have the benefit of your comparison of the old and new.
Dawn Marie might have to drop the channel in there. I don't know why the link isn't working. I just got it off her channel.
Yeah, I turned it off of the Discord link. Thank you, Dawn Marie.
Angel Baby's got you.
Nice. That's it. That's our girl.
Angel to the rescue, as per
Right.
you.
Yeah. Now Dawn Marie owes me 200 subs.
On the double.
See the math though? How that works? Okay. It's not good math. Not good for Dawn anyway. Good for me though. Good for me. Glad Misty's here.
Both.
Misty's off work on Mondays.
It's good. What is it? It's good auspices, good karma. Oh, but nice. Misty, you're off. Cool.
I think it's time to do some
So tomorrow is Proctor, right?
Proctor where?
Isn't Proctor supposed to participate in the same thing that Lally is doing?
Oh, yeah, probably.
Yeah.
Probably. I hope
I thought
so.
he was supposed to be today. That was the title or the caption of Melanie's video this live stream this morning, but I don't know how I heard, I guess from I guess in the Discord that Proctor never made it. I think they just, I don't know if he was supposed to go today, but that was part of the live stream. So
Dawn, I saw a couple videos about it. But I didn't watch any.
Oh, Dawn Marie, yeah, a little bit. I just saw something in passing, but I am so pissed off about that.
That dude
I wish that guy had to face a trial, and I'm really bent out of shape about the mom, like
Yeah.
allowing this monster to like putting them in the same bed, knowing that they're in the same
Oh,
bed, and
God.
God knows what else.
Disgusting.
Horrible, disgusting, and it's like, what the fuck, Florida,
We should
right?
be able
This
to
is
stone
Florida.
him.
It's Florida, right?
It's
I mean,
horrible.
what the fuck? It's the same thing with I know you guys know that I followed the Timothy Ferguson case, and you don't know a lot about it, but the reason Timothy was with his evil monster demon of a mother, I say mother loosely, was because the fucking father just shirked his responsibility completely, didn't do any follow up, didn't check in on him, and it's like, why wasn't he charged? He was a minor. Timothy was, I believe he was 14 when he got into Shonda's, you know, cloven hooves, and you know, why is Jen Soto not charged? I don't get it.
She needed to be charged with something
I hope
because
so.
it's negligence, about
Yeah.
as negligent as you can get.
Yep.
This
100%.
dude's in there trading porn, kitty porn on the dark web in your house.
Disgusting. And she would say, "Oh, I'm not feeling well. You
And he
know,
rode around with her in the car, and then
I
Toy was watching the videos last night of the body cam footage. It's just like he's standing there. You can almost tell he's shaking, about to fall out.
yeah,
Been up lying, waiting
yep,
for the wee hours of the morning to throw all her shit in the dumpster and ride around with her in the fucking car.
right,
Yeah.
right. What do you think? So, Laureen was saying that she thinks that, and it makes me sick to even say it, that Maddie was pregnant, and that's why he did what he did, why he killed her. I mean, I guess I don't know if we're ever going to find out about that, but
We'll never find out. Just like Koberger, they'll run him deep into prison somewhere. We won't see him again.
right. You think he's going to survive?
If they got him some type of deal for pleading guilty, where he can just be in solitary for the rest of his life.
I think he's supposed to initially, but the plan is, at least from what I had heard, that they're going to try to integrate him into Gen Pop. I don't see him surviving that. Gen Pop?
If he's smart, he'll stick something in the first dude's neck he can reach.
Right. Right. Yeah, yeah.
Go get his
Send a
private.
message. Yeah.
Or you can find the squirrel man.
Start making hooch.
Yeah.
Get that Koberger hooch.
Right.
They'll
Yeah, money
I
goes
would
far.
do that to him because he's not like a pedophile or anything. But Steven Stearns ever gets anywhere near Jim Pop or another inmate, that would probably do him in for the
Yeah.
rap.
Look what happened to
Right.
right? And Bulger. Well, Bulger was a little bit different, Whitey, but Jeffrey Dahmer, how long was he in? I saw it the other day. It wasn't long. I think it was like what, 2 years?
Yeah, it wasn't long for him.
Thank God.
Yeah. Dahmer was different.
Toilet bowl.
He was gonna make it for a while there.
Yeah, Prince Lever. Ugh, good God.
Hooch.
It's a different world.
Go in JFK's chat and they'll tell you all about it. Him and James, they'll talk about it in prison time.
They made hooch.
Oh, I don't know. I got a little nephew that has been in prison.
Aw.
Jail.
How's he doing now?
I have no idea.
Is he out?
I don't know.
Okay.
Could be. Could
I
not
hope
be.
so.
Yeah, we hope so. But
Yeah.
you never can tell. But
Mm.
he's really good at making prison wine. He gets in there and he knows all those little tricks where you can make all this shit.
Mm.
trade it for goods.
Yeah.
Let's see if a little bit of Alan Jackson will warm us up.
Yeah, right. A
There
little
was
less.
no collision. There was no collision. I want to take a minute to start off with thanking you. I want to thank you for your attention. I want to thank you for your patience. I want to thank you for your diligence. This is not an easy undertaking. Most of all, I want to thank you for your courage, because courage is what this moment demands. Not just to listen, but to stare directly at injustice and say, not here, not now, not on our watch. That's what you're being asked to do. Stare down injustice. I want to start with a simple truth. You folks, not us, nobody else in the courtroom, you folks are the last line of defense. The last line of defense between an innocent woman and a system that has tried to break her, that falsely accused her, that tried mightily to bury the truth. This case was corrupted from the start. It was corrupted by biases and conflicts and personal loyalties that you heard about. And most fatally, it was corrupted by a lead investigator whose misconduct infected every single part of this case from the top to the bottom. In our opening comments to you a few weeks ago, we told you what to watch for. We warned you what to watch for. We begged you what to watch for. Watch for the physical evidence. Pay attention to the medical facts. Pay attention to the science and the physics. But also pay attention to the integrity, the very essence, the integrity of the investigation. But you also saw something during the course of the trial that none of us might have expected, something that should sadden us, something that maybe would anger us. On full display, you saw the lengths to which some police officers will go to protect their own.
It's already good. It's already done got good.
At the expense of the rest of us. At the expense of Karen Reid, an innocent woman. Before we examine the evidence in the case, which we will do, we need to understand the very foundation of the entire system of justice in which we operate. It's the bedrock on which this entire system is built. Reasonable doubt. This isn't just a technicality, and it's not a slogan. It's a constitutional shield that protects the innocent and prevents the government from punishing without proof. The Commonwealth has the high burden to prove every single element of every single charge beyond a reasonable doubt and to a moral certainty. As I said, those powerful words are not just some legal jargon. They're your mandate, they're your obligation, they're your community's protection against injustice. In our system of justice, Karen Reid sits here today, presumed innocent, cloaked in the presumption of innocence. That presumption is not fragile. It doesn't just disappear because there's a charge or a badge or a theory. That presumption stands firm unless and until the Commonwealth clears that high bar, the highest bar the law provides, proof beyond a reasonable doubt and to a moral certainty. That means at the end of this case, at the end of the trial, you think about one or more of the charges, you think, you know what, maybe that's true. It might be true. Then you vote not guilty. If you think it's possibly true or probably true, your vote must be not guilty. If someone among you thinks...
Night, sweet woman.
Good
Everybody,
night, guys.
sweet woman. Good
Good
night.
night, sweet woman. Until next time.
Yes.
Sleep well.
Till next time.
Yep.
Should probably be tomorrow.
Yep.
Better
It
be.
might,
Hope so.
might not be. I might quit today.
Well, we
You
still
would
have
never.
Discord. We could still chat.
I'm gonna pull a Matza and just take it all down.
Oh God.
We'd find you.
And shockwaves throughout our Discord.
Oh, I know. YouTube would just be like sending me letters in the mail. Thank you for leaving.
It's likely true, or even very likely to be true. Your vote is not guilty. Because none of those standards, maybe, might be, possibly, probably, likely, very likely, none of those meets the extraordinary burden of beyond a reasonable doubt and to a moral certainty. A moral certainty means a level of confidence so strong, so incredibly unshakable, that you could go home, you would go home, look your loved ones in the eye and say, I am certain. Not probably, not likely. I'm morally certain, and my certainty remains unshakable. The law defines moral certainty as the highest level of certainty known in all human affairs. Think about that. You must be that certain about the entirety, not part of, the entirety of the Commonwealth's case. As we discuss this case, you'll see that the Commonwealth comes nowhere near, nowhere close to reaching that extreme burden of proof. Ladies and gentlemen, on January 28th, 2022, it was a Friday night. John O'Keefe and Karen Reid made plans to meet up with friends, go out for drinks. You saw from video evidence and eyewitnesses that they were affectionate, they were loving, they were in good spirits throughout that evening. They started off at C.F. McCarthy's, which you've heard about, and eventually made their way over to the Waterfall Bar and Grill. When they got there, the Albert family, they were already there, and they were already drinking. The Albert family, it's been established as a very well-known family in Canton. They've got quite the reputation. Brian Albert was at the Waterfall, a longtime Boston police officer. His wife, Nicole Albert, was there. She was with him. His brother, Chris Albert, who was a Canton board selectman, he was there. His wife, Julie Albert, their daughter, Caitlin, and his sister-in-law, Jennifer McCabe, whom you met, and her husband, Matthew McCabe, whom you did not meet. They were all there drinking before John and before Karen ever arrived. But also present at the Waterfall that night was Brian Albert's friend, Brian Higgins. We know that he had a romantic design on Karen. That becomes an incredibly important fact as we discuss the facts of this case. As the bar was closing around midnight, the Alberts invited everybody back to their house. They wanted to keep the night going. But the evidence revealed something interesting, that the invitation to John O'Keefe appears to have been for a different reason, an alternate reason. Think about the video of Brian Higgins and what Michael Proctor in his investigation completely and utterly ignored. Higgins was agitated after a day of drinking, agitated that it was John and not Karen, John with Karen, not him. Recall that ominous text that he sent to Karen with her and John standing just feet away. Well, he got no response. And then we see this. That's what Brian Higgins was confronted with following his well text. What of all things starts going through Brian Higgins' mind? Where does his mind go? What is he thinking about after seeing this, after witnessing this? He shows you. And if Michael Proctor had been the least bit interested, this video would have shown him too. Take a look. Sparring, practicing, fighting techniques. Where was Brian Higgins' mind? What was he thinking about? And then what happens? Before you look at the next video, think about what you're going to see. This next video is after he sees John kiss Karen on the forehead, after he sends that aggressive text to Karen with her standing just feet away. Watch closely, and this is what you're going to see. This is what Michael Proctor and his investigation completely ignored. Higgins is very clearly upset. He's agitated. Chris Albert tries to control him, tries to talk to him, calm him down perhaps. Chris forcefully grabs Higgins' arm. You'll see that in the video that you're about to watch. It appears that Chris is trying to calm him down from something. Brian Albert's standing right there with the other two men, but Brian Higgins is having none of it. He appears to be hyper-focused on one person and one person only, John O'Keefe. In an instant, Higgins angrily jerks his arm away from Chris. Higgins rubs his brow, and he directly gestures at John, a gesture that looks a lot like, let's step outside. Let's go outside. But John looks at him, takes a swig of beer, completely ignores him. Take a look. Michael Proctor, the lead investigator in this case, had all this footage, but he did nothing. He had access to the exact same thing that you saw. Why did he do nothing? A few minutes later, Higgins then texts John directly. You coming here? 3 question marks. It's now 12:20 a.m. These guys are not good friends. They barely spoke or even acknowledged each other when they walked into the bar together, other than a quick greeting. So why was Higgins coaxing John over to 34 Fairview? You coming here after this? And why not text Karen? Because at that moment, he wasn't interested in Karen. He was interested in John O'Keefe. This is about 5 minutes before John gets out of the SUV and walks toward the house, about 5 minutes before Karen sees him alive for the last time. So what happened inside that house, or that basement, or that garage? What evidence was there for the investigators to look into? What did they ignore? Laceration over John's right eyelid, black eyes, a large dog at the home, an obvious dog bite on John O'Keefe's right arm, a head injury from falling backward onto a hard surface, alleged surface, a text from Higgins, one of the last people to ever communicate with John O'Keefe. "You coming here?" Those words now echo in the wake of John's death. But Michael Proctor, he didn't listen. When John didn't come back outside, Karen, very oblivious to what had happened, thinking she was just left alone in the car out in the cold in the middle of the night, she got frustrated and she drove home. She arrived back at home and her Wi-Fi connected to her car or phone connected to John's Wi-Fi at 12:36 a.m. It's an important time, 12:36 a.m. She left John voicemail after voicemail after voicemail. He was unresponsive. He didn't pick up a single call. He didn't respond to a single text. The longer he didn't respond, the more upset she got. Her voicemails reflect that frustration after the fact. That's the frustration that you hear in her angry voicemails. She uses harsh words and foul language. She's obviously upset. She's obviously irritated because he didn't come back out of the house and he wasn't responding. But Karen did not know what you know. She didn't know what the investigators should have known. She didn't know what was happening with Higgins and Albert and with her boyfriend, John O'Keefe. When he didn't come home at about 5 a.m., Karen went looking for him in a panic. As you know, her worst fears were realized when she found John beaten, battered, bloody, and left in the snow in Brian Albert's front lawn. At 6 a.m., when Karen found John, you heard about the scene. It was described in detail. It was chaos. To use Mr. Brennan's word in his opening statement, it was bedlam. The screams for help by Karen, the yelling and the hollering, ambulances, emergency lights, fire engines, ladder trucks, paramedics, patrol vehicles, patrol officers, all of them swarming all over the lawn just under Brian Albert's bedroom window. And of course, as you learned during the course of this trial, Brian Albert, a sworn peace officer, a first responder trained in being a first responder, never came out of the house. Never went outside to help a fallen fellow officer who was laying on his own property. Never came out. And you learned through the undisputed evidence that the lead investigator, Michael Proctor, for his part, never went into the house. The Commonwealth has struggled to try to prove that John O'Keefe ended up in Brian Albert's front lawn because he was struck by a vehicle. They have failed. They cannot and they will not ever be able to prove that John was struck by a vehicle beyond a reasonable doubt and to a moral certainty, because the science does not lie, the medical evidence does not lie, the physics do not lie. Their investigation was flawed from the start because their investigator was corrupted from the start by bias, personal loyalties. Folks, they cannot prove a collision. John O'Keefe was not hit by a car. There was no collision. So let's start there. I want to take a minute to discuss the actual science, the actual physics, and the actual medical evidence that was presented in this case. The science, it's an old saying, is known as the silent witness. It doesn't lie, it doesn't forget, and notably, it doesn't take sides. If there was no collision, what are we doing here? In order for there to be a collision, there has to have been an impact site. The vehicle had to have struck John, period. I want to remind you of some of the most important testimony in the entire case, and it comes from the Commonwealth's own medical expert, Dr. Riiiide Scortibello, the Commonwealth's medical examiner, someone governed by law to make these decisions. We know that a person struck by a vehicle suffers massive trauma, broken bones, fractures, soft tissue damage, torn ligaments, contusions, soft tissue injury, severe tissue injury, crushing blows. None of that was present with John. None of it. Not anywhere on his body, including his right arm. Not one bruise. Nothing. The fact is, the injuries are not from a vehicle impact. Not his head injury, not those scratch and bite wounds. Not a single medical expert. Think about this. Not a single medical expert called by the defense or called by the Commonwealth has testified that John was hit by a car. Not one. Think about the irony. Not one. That's not just significant. It's literally the most important point in the entire trial. Listen again to Dr. Scortibello's words. Question. You did not include in your autopsy in any fashion any discussion of whether Mr. O'Keefe's injuries were consistent with a motor vehicle accident, did you? Answer. No, I did not. She told you, quote, I did not see any evidence of an impact site, end quote. She was talking about John's body. The Commonwealth's own medical examiner, Dr. Scortibello, performed the autopsy. She did it personally. She's the only one to have personally examined John's body, and she found no evidence of an impact site on his entire body. That in and of itself is reasonable doubt. You don't need anything more. The Commonwealth's case is done. It's cooked. Their own expert said there is no evidence of a collision, no evidence of an impact. If you want to know what an impact looks like, take a look at this. This is what a body looks like after being struck by a car at 25 miles an hour. And this is what a car looks like after hitting a person at 25 miles an hour. These are exhibits from Dr. Welcher, the Commonwealth's expert. John didn't even have a bruise. Make no mistake, Dr. Scortibello was presented with the Commonwealth's theory of the case, the same case that you've been presented with, and she refused to conclude that John's death was a homicide. She flatly refused to conclude that there was a collision. And you know who agrees with that? That silent witness, the science, the physics, the data. Dr. Wolf and Dr. Rentschler, you just met them recently. They explained they were not initially hired by the defense. They were asked by another agency to conduct their analysis. They looked at the evidence from both sides, not taking a side for the defense or the Commonwealth, completely independent. They looked at the damage to the SUV on the one side of the coin. They looked at the injuries to John O'Keefe on the other side of the coin. Both PhDs, both engineers determined there was no collision. I'm not saying it. The science says it. That SUV's taillight was not damaged by striking an arm, and John was not struck by a 6,000-pound SUV, period, full stop. Dr. Dan Wolf did the testing on the taillight, actual testing, not some ridiculous blue paint kindergarten project. He did lab testing. He did field testing. He did data testing, actual impact force analyses. In every single test at every single speed, the taillight damage was inconsistent with striking an arm. In every test, the taillight damage was inconsistent with damaging the shirt, the sweatshirt. Remember that severe internal damage to Karen Reed's taillight, not just the outer lens. The internal diffusers were completely smashed, completely shattered. ARCA testing established that all the internal components of every single test taillight, especially the diffusers, remained completely intact. Conversely, on Karen's taillight, the diffusers were almost completely gone. Folks, understand something. If any part of that diffuser portion of the taillight is broken, there is no light. It doesn't illuminate at all. It's just black. Let's take a look at a couple of photos. At 5:07 a.m. at One Meadows, that's the photograph on the left. What do you notice about the right taillight? It's completely illuminated. Later, at 4:12 in the afternoon, photograph on the right, it's lit up. How can that be? How can that be if the Commonwealth claims that those diffusers, the portion that lights up the light, were already scattered all over 34 Fairview? That's their theory. But don't believe your lying eyes. The taillight's completely lit up. That would be impossible. Dr. Andrew Rentschler, PhD, a biomechanist, explained that at those speeds, the other side of that coin, John's arm would be basically destroyed. Contusions, swelling, torn ligaments, hyperextensions, dislocation of joints, and bones, fractured, broken, and shattered. But as you know, John's arm was pristine, save those dog and claw bites. He didn't even have a bruise. Think about this. Think about that photo of those x-rays as you deliberate. You can manipulate a taillight fragment. That's not that hard. You can't manipulate a bruise. If they claim the car was going fast enough to shatter the taillight and shatter the diffusers, then it was also going fast enough to destroy and shatter John's arm, and it simply did not. How do they square that? They don't, and they can't. So they spent nearly $400,000 of taxpayer money to hire someone to dress up and look like John and paint his arm blue, which told you exactly nothing. The ARCA testing, conversely, also established that it is impossible for John's sweatshirt sleeve to be damaged by an impact with the taillight. The Commonwealth's theory is that the sleeve of John's hoodie sweatshirt was damaged by flying shards of taillight slicing through the shirt and through John's arm. I have 3 questions. Number 1.
You see how rude MJ is? Just come up in here being rude to everybody. Mary B, that's your friend.
I'm fine with it.
Well, she's rude.
I was just answering. So you have to be careful about what you post back, and I was like, oh, wait a minute. I see this as a joke, but maybe I have to explain it. My response. I get it. She's passionate about animals. But I saw that I had to post it. That is fucking crazy. But yeah, New Jersey, crazy. Do you want to mention what we're talking about? That MJ is very passionate about.
Yeah, what is it?
The poor seagull. So apparently,
Oh my God, yes. I was so mad about that.
crazy.
Like, they're annoying, but seagulls are pretty cool. Like, they're kind of badass when you think about it.
It's what they fucking do. I mean, they're they're rats in the sky. That's what my friends used to call them. They're the rats in the sky. But that's what they do. They go to the beach and they wait for you to drop a French fry. And then the father, I guess the girl was eating French fries, and then the seagull snatched the French fry, and then he decapitated the fucking bird. Are you kidding, guy?
People are insane.
Yes. Yes, they are.
I wish one of us could find Mary Whitcomb's rat suit for her. Toy probably can, but I can't remember which video it's in.
Yeah.
I wonder if Little Miss has ever seen a video that looks something like that's all we can play.
Aw, Little Miss. Played your song. Oh, bless you, Danny. She loves that so much.
She's got it. She's working on it.
That is a good question, Prince Lover. How did he catch a bird?
Yeah.
Hey, Cherry.
Hey, Cherry. What's up?
Cherry. Awesome sauce. What are you doing, Cherry? Cherry and my wife showed up same time.
Hey, Toy.
But Mary Whitcomb, you definitely have a rat avatar toy made for you somewhere. One of us will find it. Check Discord every day and we'll find it for you.
MJ.
Oh, God.
When her daughter was little, she would call seagulls eagles. A little bit of a difference.
How are you like?
That's what my crazy friend, the one that I went to Italy with, she used to call the seagulls the rats in the sky. It's true.
They are.
Yeah.
Night, Little Miss.
Oh, good night, Little Miss. We love you.
Good night, Miss.
All right. Back to this.
John's arm had about 36 abrasions. How did 36 shards of acrylic go through 9 tiny little puncture holes? How'd that happen? Somebody needs to answer that.
Somebody.
Number 2, why are there no slices or cuts in the hoodie? All the defects are punctures. Punctures that you might get from, say, I don't know, canine teeth. And number 3, if the shards cut bloody gouges into John's arm, that's their theory. Why is there no blood, no skin, no tissue on a single shard of taillight that they claim came in contact with John's arm? The Commonwealth cannot answer a single one of those questions because John's arm was not impacted by the taillight. It doesn't make sense simply because it didn't happen. Compare and contrast the ARCA experts and their actual testing to Judd Welcher. He came to you in the Commonwealth's case in chief, and he told you that for the better part of $500,000, he'd come in and testify that John was tall enough to touch the taillight with his elbow. That's it. And even in that basic demonstration, he had to lean in to manipulate it to get the results that he wanted. Dr. Welcher then claimed that the reason he didn't do the reconstruction, the actual testing, think about what he said. There isn't enough evidence to determine what happened. I beg your pardon? What happens when there isn't enough evidence, in his words? You vote not guilty. That's what happens. That's out of his mouth, not mine. The Commonwealth also used the same company, Aperture, to try to establish a time of a collision that never occurred. The Commonwealth called Shannon Burgess, the supposed expert from our.
This is for Cherry right here. Hope we don't get in trouble.
He thinks he's a French fry. Hey, chicken, you got a lot of nerve hanging around with those French fries, man. Maybe you want to be a French fry, huh? Maybe I do. Oh. Maybe you do. Maybe I do. Maybe you do. Maybe I do. Yeah, maybe you do. Okay. Maybe I do. Yeah, maybe you do. Yeah, maybe you do, man. Maybe I do want to be a French fry. PK chicken fries, all white meat chicken.
Okay, sorry. I had to do that. You wouldn't understand.
Gross. Chicken fries.
I don't, and it's okay. I'm good.
We were in Voice Chat one day a long time ago, and I was going to Burger King to get us something to eat. And I was ordering chicken fries, and the dude kept repeating it back to me weird.
Mm-hmm.
And Cherry just wanted chicken fries ever since. Chicken fries.
I don't know. Have you had a chicken fry? I don't know about chicken fry, but we used to go to White Castle. Do you have White Castles down south?
Nope.
Oh man.
We got Crystals though.
Crystals. You have those in Mass, right? White Castle?
None around me. I remember going to them a lot in New York when I lived there.
White Castle is like, it's like Jack in the Box. It's the 3-4 a.m. just go in, make trouble. And they had like chicken, not chicken fries, but they had like the chicken, you know, the donuts. What the hell do you call them? I don't even know, but they were like chicken rings. Yeah, there you go. Like, I don't know. I think in a desperate moment, I ate them, but but it's similar. It's the same thing as a chicken fry. Chicken fry. The chicken ring is just a chicken fry that's like made into a ring. That's all. It's the same shit.
I'm gonna admit though, KFC had KFC had a chicken pizza, so it was like a piece of fried chicken or two pieces of fried chicken next to each other and like pizza toppings. And
yeah, like chicken, like a chicken parm pizza.
Yeah, but it was weird. It was super weird, but got it because I was like, why not?
But
and
the thing you'll
it was
eat
awesome.
At like 4 a.m. or 3 a.m. when you're, you know, when you're shit faced and you just need something. Yeah, that'll do.
Yep,
that'll do.
I'm partial to McDonald's, but I'm a traditionalist, you know.
Yeah, no, I gotcha. And we had Jack in the Box too, but it was a grimy, dingy, dirty Jack in the Box that was like right next to the pool hall. It was something. It was a seed, but yeah, you have those down south, right? Jack in the Box.
Nope, we got Crystals.
Oh, Crystals. Oh, okay, that's right. So Crystals is basically the same thing.
Yeah, basically.
Well, you need something.
Okay. That sounds so good right now. McDonald's is not expensive if you use the app. I get free fries every day.
Yeah, my son, he uses the app too. I don't know. I'm not that adept. I don't know. I just go for the fries.
So everybody will know what we're talking about.
One of my favorite things in life are the McDonald's fries. I mean, nothing in life close to McDonald's fries. There's nothing that compares.
No. And their soda too. I don't know what they do to their fountain, but they make it magical.
Because McDonald's has
nice. Yeah, Coca-Cola. Yeah.
And they use different lines. They don't allow them to use plastic, CO2, and syrup lines. They have to use stainless steel.
Really?
Yeah.
That is interesting.
That is interesting. We just learned something, Mary B.
Yeah,
Chat,
what fun facts.
we learned
Supposed to.
Rat facts.
rat facts.
Yeah.
Their new segment.
All right. Back to this.
There is a cardinal sin for experts, folks. A cardinal sin. It's called confirmation bias. It's when you decide to change your opinion to fit a theory. The most important takeaway from Shannon Burgess' testimony was how brazen, how shameless he was in trying to change the data to try to suit the Commonwealth. Remember Mr. Brennan's opening statement. He made some promises to you. He said, this case is about the data. He stressed it over and over again. They've had 3.5 years to get this right. The Commonwealth has had this case for 3.5 years to get it right. So his top expert, Dr. Welcher, prepares a report. And that report says that John O'Keefe was struck by Karen Reid's SUV at 12:31:38. Note that time, 12:31:38. He was struck, he was immediately incapacitated, he was immediately unconscious. So says Judd Welcher and the Commonwealth's theory. But there was a huge, huge problem with that. And somewhere in the middle of trial, somebody must have realized it. They must have realized that the very data they produced unequivocally establishes that they are wrong about a collision. It could not have happened. Why? Because John was interacting with his phone after 12:31:38. Remember, the collision immediately incapacitating. How could he be interacting with his phone afterward? He was on his phone, opening his phone, checking his phone, reading texts on his phone, and locking his phone, all of it after 12:31:38, which is the time Welcher clocked for the moment of the impact. And he was taking steps and walking with that phone after 12:31:38 also. That's what their own data showed, and it devastated their case, and it devastated that false theory. There must have been panic, I'm guessing, in the room. What do we do now? The data shows John wasn't struck by the car. What do we do? Enter Shannon Burgess. Question, can you believe him? Can you believe Mr. Burgess? He came up with a brand new story right in the middle of trial. You might ask yourself, would an expert actually say something he knows not to be true? Would an expert actually say something he knows is not supported by fact? Would an expert shade the truth? You don't have to look any further than Shannon Burgess's CV to answer that question. That was a shame. Even with the pull and push and stretch and manipulation of the time data that Mr. Burgess came in here and told you about, it still shows that John O'Keefe was very much alive and walking around after they claim he was hit and incapacitated. Think about that. Matt DeSogra looked at Burgess's report and told you that in 30 out of 30 scenarios of the possible time skews that Shannon Burgess identified, he came in the middle of trial and identified all these other time skews that he called it. In every single scenario, John was alive and walking after they said he was hit. And that's a problem for them because there was no collision. Just look at Mr. Whiffen's data, Ian Whiffen. John O'Keefe took 31 steps at a steady rate, about 83 feet. And then think about this, in a westerly direction. That would be right toward the house. Remember, it's 78 feet to that garage door. That's not a coincidence. The Commonwealth's witnesses, or the Commonwealth's witness, Mr. Ian Whiffen himself conceded that he has reasonable doubts about the accuracy of John's location data. You remember that question and answer on cross-examination by Mr. Alessi. Do you have doubts? I do. Are those doubts reasonable? They are. And remember, it's still the Commonwealth's burden. If their own cell phone expert has a reasonable doubt about John's location, so should you. John O'Keefe was inside, and the phone battery temperature further proves it. This is not speculation. This is science, and it's irrefutable. It tells us that he was not laying outside in the cold. He was inside somewhere a little bit warmer. Ian Whiffen told you that when the iPhone is exposed to freezing temperatures, think about these numbers. When the iPhone is exposed to freezing temperatures, it will drop from 81 to 21 degrees in 15 minutes. 15 minutes. That's a 60-degree drop in 15 minutes. Now look at John's phone. It was laying, according to the Commonwealth, it was laying directly on frozen ground. He arrived at 34 Fairview and his phone dropped only 20 degrees over the course of an hour. Then inexplicably, it stayed steady, never dropping below 50 degrees for the next 4.5 hours, never dropping below 50 degrees for the next 4.5 hours, basically through the entire night. He was not outside. He was someplace warmer, like a basement or a garage. Dr. LaPosada confirmed that John O'Keefe did not have hypothermia. No telltale signs, no telltale Wisniewski spots, no frostbite on any extremity. He did not die of hypothermia because he wasn't outside. Dr. Isaac Wolf, Dan Wolf, Elizabeth LaPosada, Judson Welsher, Andrew Rinchler, all agreed. Every expert agreed. This is how John O'Keefe died. A rearward fall from a standing position. What could make you fall straight back like that? Let's just think about that for a second. What could make you fall from a standing position as Judd Welcher just showed us? Standing up, falling straight back. Add a laceration to the right eye consistent with a fist or a punch, and you've got your answer. He certainly didn't sustain that wound on the back of his head by falling backwards onto a lawn. Dr. LaPosada told you that the patterned injury on the back of John's head could only be produced by hitting a hard, ridged, or ledged surface, like a concrete stair or step. What's just through that garage door? Michael Proctor never stepped down in that garage to find out. What a shame. And look at the arm. Just look at John's arm. You don't need the top experts in the country, but you had them. You don't need the top medical minds on the planet on this issue, but you had them. These are dog bites and scratches. These are animal wounds. Not one witness has been called in their trial. Not one. 8 weeks and counting. Not one witness who actually disputes that John O'Keefe's arm injuries are from a dog. The Commonwealth could not find a single medical expert, a single medical witness who would come in here and tell you those are inconsistent with a dog bite or a scratch. And it's equally clear that there was no collision. Dr. LaPosada told you in probably the clearest voice in the entire trial. You remember her testimony. He didn't get hit by a car, in her words. He just didn't get hit by a car. You remember the question that was posed by Mr. Brennan, did you consider the speed of the vehicle? And she said, speed didn't matter because he didn't get hit by a car. She repeated it 3 times because it's true, not just because she says so, but because the medical evidence proves it. The medical science proves it. There was no collision. Dr. Rinchler told you unequivocally and just as firmly he didn't get hit by a car. The Commonwealth has not met their burden. They cannot meet their burden. The Commonwealth hasn't called a single medical professional, not one, to testify that John's wounds came from being hit by a car. Not Dr. Scortibello, not Dr. Isaac Wolf. Contrast that with the caliber and the quality of the experts who came in here to tell you what is obvious to anyone with common sense. Those wounds on his right arm are from a dog. This was not an oversight by the Commonwealth. It's just that there is no one out there. No matter how big a check you write, there's not a medical expert who's going to disagree with that. The fact is, this is the central fact in the case. The only fact that matters is literally uncontested by every medical expert. Uncontested, undisputed. There is no evidence that John was hit by a car. None. How much more reasonable doubt could there be? This case should be over right now. Done. Because there was no collision. So given all that, how did Karen Reid end up sitting here? Why is she even here? Why is she in that chair? Why is she in this courtroom? There is a reason for that. And it's a reason they don't want to tell you, and it's a reality they don't want to admit to. The reason we're here is because the system, the very system that was meant to protect her, that was meant to protect all of us, that system has failed badly. So now let's discuss the facts that were and were not presented by the Commonwealth in this case. Over the next few minutes, I want to talk about the utter failure of the police to investigate this properly and to investigate this fully. And what you're going to see is that Michael Proctor, the lead investigator for the Commonwealth, did nothing to actually and properly investigate this case. Let's start with the house. That's the most logical place to start. I think you'd agree. Brian Albert's house, where John's body was discovered lifeless in the lawn. A man, a police officer, is found dead on the front lawn, and no one secures the scene. No tape, no preservation of evidence, no crime scene log, no search warrants, no consent searches, no photographs of the house interior. They didn't treat the house as a crime scene, and shamefully, they didn't even treat the yard as a crime scene. The lame excuse offered by retired Lieutenant Gallagher, it was really cold and windy, and I didn't know if there was a crime that had been committed. What? You didn't know that a crime had potentially been committed? You have a man laying dead in the yard, and here are the undisputed facts that those officers were confronted with. Black eyes. Obviously, black eyes are consistent with a fight. Bloody nose, also consistent with a fight. Bleeding from the face, consistent with a physical altercation. A cut over the right eye, consistent with a punch, no coat in the freezing cold, not dressed for outside, dressed for inside, and one shoe on. I wonder where the other shoe could be. I don't know, maybe in the house 30 feet away. And then you find a broken and shattered drinking glass next to him, the type of glass that you might find, I don't know, let me think about this, in a kitchen, in a house, 30 feet away. And John's phone was tucked neatly under his back shoulder. Lieutenant Gallagher actually claimed he did not know it was a potential crime that needed investigating. The neighbor across the street, Detective Lieutenant Kelleher, had a ring camera that was pointed at the exact direction where John O'Keefe would have been hit, and nobody bothered to secure it. Nobody bothered to secure it. Nobody even bothered to look at it. Of course, this was a potential crime scene. Of course it was. Let's not forget, this was Brian Albert's house, and that comes with privileges. Quote, is the homeowner going to catch any shit? Nope. He's a Boston cop too, end quote. That quote starts to make a little more sense now, doesn't it? Michael Proctor wrote those words just hours after John's body was found. He sent this in a private chat, in a private text he never, ever believed would ever be revealed. He sent that text in a series of messages that now belong to you. You weren't given the opportunity to hear from Michael Proctor, but you can read his thoughts for yourself. And I urge you, go read them. They're in Exhibit 209, in case you're wondering. But here are the highlights. Proctor starts the conversation, quote, all the powers that be, one answers ASAP. He's getting pressure, obviously, to get this done. His friend then asks what Proctor's probably thinking at the time, quote, I assume you guys are out to make it cut and dry since it involves cops. Something stinks. And Proctor responds, yeah, to the something stinks. And then he goes on, but there will be some serious charges brought on the girl. Think about that. Hours into this investigation, there will be some serious charges brought on the girl. She's a whack job cunt. Yeah, she's a babe. Weird Fall River accent though. No ass bitch. She's got a leaky balloon knot, leaks poo, 0 chance she skates. She's fucked. And up to this point, Michael Proctor had done 0 investigation, nothing, save talk to a grand total of 3 people, all of whom were named Albert or McCabe. That's it. And this was his mindset. This is the same lead investigator who sent the group chats that you heard about with Sergeant Butnick. Late night, sitting at his office, rifling through Karen's phone, bragging about looking for naked pictures of her. That text wasn't sent to his buddies or his friends. That text was sent to his supervisors at the Massachusetts State Police, for God's sake. And what was their response? Sergeant Buchanan liked this conduct with a big old thumbs up. He encouraged it. Ladies and gentlemen, a lead investigator every investigator is supposed to be objective, an objective fact finder, no bias, no agenda. Michael Proctor went far beyond just insulting Karen Reid. He dehumanized this woman. He betrayed her as a human being. He was fired for this blatant bias. If the Massachusetts State Police can't trust him, how can you trust him with this investigation and with your verdict? And with Karen Reid's life? The lead investigator in a murder trial was never called to testify. Think about that. That should stop you in your tracks. Wouldn't you want to hear from Michael Proctor? Wouldn't you want to hear from the lead investigator in the case? Don't you have questions? The Commonwealth did not present their own lead investigator to the jury, the very jury who was charged with judging the investigation. Michael Proctor clearly is radioactive, and the Commonwealth stayed away from him. Michael Proctor is no longer a Massachusetts State Police officer. He wasn't transferred. He didn't go on sabbatical. He didn't retire. He didn't resign. He was fired. He was terminated for cause. The Massachusetts State Police investigated him, found him guilty of dishonorable conduct, not just for those text messages, folks, for sharing confidential information with witnesses and for bias. Not just any bias. Bias in this case. Fired. This is the man who touched every single piece of important evidence in this case. All the evidence that was brought before you in this trial went through his hands one way or another. The shirts, the shards. Remember that when Mr. Brennan gets up and gives his closing argument. The shirts, the shards, all in Michael Proctor's possession. Mr. Brennan and the Commonwealth, I think, have pinned their hopes on some microscopic pieces of, or close to microscopic pieces of plastic. that were claimed to have been scraped from the hoodie several months after the fact. What he failed to ask every single every single witness, is who had access to that shirt and who had access to those taillight fragments. And the answer is it was Michael Proctor. Not for days, not for weeks, for months on end, for months unaccounted for, before they were submitted to the crime lab, before they were ever scraped. Just go look at the chain of custody documents. You got them. Why didn't Michael Proctor give those clothes to Maureen Hartnett with the crime lab when she was at Canton PD just days after the fact to receive those Solo cups? Remember that? Just a few days later, she was there. She drove up. She did the driving to take the Solo cups in the grocery bag, which has a ridiculous aspect to it in and of itself as well. Why not just give her the shirts as well? Give her the taillight fragments if any were found at that point. Why hold on to them? What could possibly be a reason? Why wait until March to book those into evidence? Now let's talk about some of the other problems with the Commonwealth's evidence. As I indicated, there was no blood, no skin, no tissue, no DNA found on a single piece or shard of the taillight that the Commonwealth claims cut and sliced into John O'Keefe's arm. Where is that trace evidence? Where is that biological evidence? The DNA, where is it? They've got nothing. Not a single piece that the Commonwealth wants you to believe cut up John's arm. How is that possible? It's not possible. The only way it's possible is if those shards never touched his arm, because it was a dog. Oh, and the one sample of DNA that they did find, by the way, was found on the outer smooth part of the housing. Not any shard, it was the outer smooth part of the housing. Nothing that they claim actually came in contact with John O'Keefe. Number two, that sample had DNA of two other men, two other unidentified males. That tells you that that DNA had nothing to do with a car strike. That DNA would be expected to be, John's DNA would be expected to be all over that car. Inside, outside, he had access to that car for months and months and months. He was in and out of it all the time. Show me some blood, then we'll talk. They can't, and they won't.
What's up, MJ?
What up?
MJ.
Hi, Daddy.
Hey, MJ.
Say it.
Hi.
What's up?
Nothing. Chilling.
You okay now after the thing that I posted in the Discord? You come.
It's just so gross. Like, I don't really care for
No, I know.
seagulls, but it's like, really, dude?
I know. I'm kidding.
It's like, come on.
People just are bewildering.
It's probably all jacked up on steroids.
Yeah, just I don't know. Jersey. I mean, you know Jersey.
Like, set a good example for your kid, buddy.
Yeah, right? You would think.
Loser.
Good job.
Loser guy.
Right. Yeah, I mean, if he's doing that, good God, the hell up he's doing. I'm just saying.
Don't worry, honey. Daddy will off the seagull for you. Weirdo.
Crazy. It's crazy.
An extreme thing to do to the seagull.
It's insane. It's an insane thing to do to the seagull. It's a fucking seagull.
It's
God,
what a
it's
hawk
their
would do to the seagull.
instincts. It's what they do, guy.
Right.
Yeah, that's exactly what a hawk would do to the seagull, though.
Oh my God, yesterday we were going over one of the bridges on the bike, and there was a dead baby hawk in the road.
Oh,
it was so tiny.
Oh, that sucks.
Hmm.
Little baby.
So sad.
Dang, MJ. You could have came up here and said something nice.
Because it doesn't exist. The SUV never hit John.
She's spitting facts.
The hair found on the bumper. The Commonwealth really stretched its own credibility on this one. That magic little.
Feel better? Tell us a bedtime story. Tell us a lullaby.
Yeah. Being Debbie Downing.
Danny needs it.
Dean, did you wake up?
Hey, Dean. What's up?
Oh,
Yeah. Oh, what's up, guys? Sorry, Daddy, I fell asleep.
Yeah, I figured that.
wow.
Yeah.
Tired little guy.
What happened? You had to nap? Is that
Yeah,
what
Nappy time.
Nice. Are you going to be able to sleep tonight now, Dean, now that you did that?
Probably not.
It's just a little colonial sleeping.
Yeah. Yeah, like Tunes and Sassy always says.
You got to do that sometimes after you've been driving a lot. Kind of reset.
Yeah.
Yeah. Oh, for sure.
Get rid of that boat on the water feeling.
Yeah. I'm a boat. Don't rock me.
Hey, Skyrocket is the best sleeper creator on YouTube. I don't even try. It's effortless. It happens. Get that good. Just put it on and get that good sleep.
I didn't even let your stream put me to sleep yet, Danny. That's how tired I was.
It's the knowing that you may hang out later that put you to sleep. It's the chi. You wouldn't understand.
Yeah.
I don't have time to explain all that to you.
That's next stream. We'll go over that.
Yeah.
What are we doing, guys? Let's get this energy fucking up. Let's fuck shit up.
Fucking go.
Some M&Ms out of the snack machine. Calm down.
Tear it up. But Danny, are we going to be able to play what Misty sent about Aaron Spencer?
Yeah, why not?
All right, cool. I mean, you could finish AJ's closing.
Yeah, we can finish that later. I want to watch this real quick now.
Yeah, thanks, Misty.
We're just going to stop this one frequently.
Missing teenage daughter in a car with a 67-year-old man, an alleged stalker. And now this father is accused of killing that man, and he could be facing criminal charges. I'm going to talk with renowned predator catcher Chris Hansen.
I think if Dean was as into true crime as we are, he could do a pretty good job, just like Jesse Weber does. Whether you like him, he's got a good. His edits are good. As you know,
Agreed. Something to think about, Dean. Meditate on that.
Meditate is my middle fucking name. Dean Meditate Talks. That's my full fucking name.
Got it tattooed across his knuckles.
All right.
Meditated.
To get to the bottom of this story.
A lot of knuckles.
Welcome to the Sidebar, presented by Law and Crime.
It's not really one letter per knuckle as you would think a prison tattoo would be. It's more like
I'm Jesse Weber. This was a wild series of events that played out very quickly in the middle of the night in Arkansas last week. So we have 36-year-old Aaron Spencer, who reportedly called 911 to say that his 14-year-old daughter was missing. And while his wife searched the area around the home, Spencer hopped into his truck, started driving around looking for her. And that is when Spencer apparently spotted 67-year-old Michael Fossler with his teenage daughter in a car. And according...
Rubicon's here. We can shut it down now.
Rubicon.
Yay.
We did it. It's over.
Woohoo!
Shut up. Let's go to the house.
Rubicon, it is great to see you, my friends.
There you go. That's the energy we need.
Spencer's wife, Heather, he started...
See, that's what Dean brought to the table.
I show up, and if you don't, they will come. If you show up, other people will show up.
That's right. We still have to.
They usually don't come with Dean.
Yeah, no, definitely.
Some people
I've
do.
never experienced that. No. Don't sell me high or tall. You know.
A lot of pressure to put on Dean, I think.
Winks is new in the chat. Look out.
Yay! Welcome, Winks.
Welcome, Winks. Where did you
Nice.
Where do you hail from, Winks? Because we've gotten a few trolls lately. I hope you're not a troll. But if you are, welcome.
Chasing the car that Fossler was driving. There was some sort of accident. After the crash, there was apparently some kind of confrontation between the two men, and Spencer allegedly shot Fossler, killing him. Well, when Lono County Sheriff's deputies arrived, they took Spencer into custody on suspicion of murder. His family was able to get enough money together for a $150,000 bail. There's a lot of different moving parts in this, including Fossler's history. So I want to bring in right now renowned predator catcher, founder of True Blue, the host of Takedown on True Blue, the host of Predators I've Caught with Chris Hansen. Who am I going to bring in? I think you guessed it, Chris Hansen, to talk more about this. Chris, good to see you.
What a wild case, Jesse.
I was going to ask you, in your experience, have you seen this kind of vigilante justice?
Apparently, the guy was already warned in some method or fashion. And so they get onto this, the father does, and he finds the girl in this guy's car. Imagine the outrage. Now, that doesn't mean it's okay to kill somebody because of this, but you have to take this into consideration. So I would have to believe that while there are charges here, and while it may be a question of fact for a judge or jury, the jury's going to be pretty sympathetic to a fellow who's in this position.
I'm going to make the argument, and we'll talk about this in a little bit, if you can even get a fair and impartial jury in a case like this. But your experience in your career, you've seen parents who have taken.
Oh, I've seen. Yeah, it's happened.
Violent with people like this.
It's happened. It's rare.
Yeah.
Most people let the criminal justice system do its job. But I just finished a sting operation in Florida with the Polk County Sheriff's deputies down there and detectives, Grady Judd, the sheriff down there. And in a matter of days, we caught a lifeguard from a Disney resort. I mean, here's a guy who's looking at children all day, and he shows up at our sting house to meet up and have a sexual liaison with a 14-year-old girl because he says his fiance wasn't paying enough attention to him. We had another guy who was in the Orlando area on business as a videographer there for a convention from Minnesota. He lies about his name. He jerks the detectives around. He lies to me during my interview with him. And it turns out all the time, all the while we're talking to him, he is out on bail after being arrested for virtually the same crime in Minnesota. So he's out on bail for trying to have sex with a boy in Minnesota. And what does he do? He goes off on business to Florida, and he gets right online and tries to set up another sexual liaison with another 14-year-old boy in Florida.
It's pretty disgusting. And I would say, oh my gosh, shocking, but really not shocking since we cover this so much. Going back to this situation, though. So Spencer's arrest, as you can imagine, it has caused a lot of outrage in the local community and online. So Heather set up a Give, Send, Go fundraising page, which has raised, our understanding, more than $100,000 to go toward Aaron Spencer's legal defense. I believe this was after an issue with GoFundMe because you're not allowed to raise money for a legal defense on that platform. So she's accepting donations through Venmo and Cash App. But a lot of people are outraged at what happened here. And a couple days after the shooting, the sheriff took to Facebook to kind of try to quell the growing unrest.
As your sheriff, it is our duty to conduct a thorough and factual investigation. Law enforcement does not file charges. We gather evidence and submit a case to the prosecutor, who will then decide whether or not to file charges. Currently, official charges have not been filed. I have not, nor will I, advocate for any specific charge.
Now, as of Monday night, it doesn't appear that the district attorney's office has filed official charges. This was more a preliminary murder charge, so there's not an official charge yet. But we are learning more about Mr. Spencer and Mr. Fossler's backgrounds. So we started by looking up the suspected shooter, Aaron Spencer, and we actually looked him up on Truth Finder. It's really easy to do. You just put in the person's name, location, less than a minute. Our paid subscription gave us access to all of these court records. And all we were really able to find with respect to his criminal history was a speeding citation in 2010. By the way, Law and Crime, we partner with Truth Finder. We use it to get details on the people that are involved in our stories. But even if you don't work in true crime, it can just be an excellent resource to give you some peace of mind. It's one of the largest. Her daughter's interactions with Fossler actually started earlier this year. She wrote, in spring, summer 2024, our then 13-year-old child was targeted, groomed, and ultimately raped by the boyfriend of a family friend. Our family did not know this monster. He just appeared in a place where our child should have been safe and got access to her phone number. And that's all it took. We let the justice system do its job. The monster who hurt our child was charged quickly, but released even faster on a $50K bond. He was awaiting court in December for several felonies in relation to what he did to our child. Now, those charges appear to include internet stalking of a child and sexual assault, but the exact details weren't available because the criminal complaint has been sealed for privacy. But Chris, that kind of gives us an idea of what we're dealing with here.
Well, yeah, obviously this guy was caught. The damage was done to this child, the grooming and the exploitation, and he doesn't learn his lesson. Just like the guys I described in our most recent sting, this guy will not stop until he is put in prison. And so that's all going to come into play when the prosecutor considers the charges against the father of the victim here. And I can't imagine that he'll see a day in prison.
The idea, though, that he goes after the person that he's accused of first targeting, not even going out and trying to attack someone, but going after the initial person. That's the part. And that's why people are outraged that he was out on bail, too.
He's a stone cold predator. I mean, what else can you say about a guy like this? Somebody like that is incorrigible. Somebody like that doesn't learn a lesson. Somebody like that can't be deterred. If you get arrested and you're out on bail pending criminal charges of this type and you go back,
what are the odds that he got busted both of those times? That he left, went to another state, got online, and set it up with another damn pants in another state.
Apparently not that good at hiding it.
Well,
how many times has he done it? Is that
we repeat patterns, right? That's what we do, and criminals follow patterns. That's why. Did you guys watch the video I posted about the New England serial killer? That they haven't linked anything, but that's why with the 13 bodies that have been found since March, they're leaning towards that it's unrelated because it's all different. And what at least they were saying, and I've heard this before, probably you guys have as well, that usually criminals follow patterns, like whether you're a sex offender, a serial killer. And I think that Koberger was ordering the knife because he was like, all right, I'm going to go for my next one. I'm not going to be sloppy, right? Like, so I'm not surprised that this monster went again, right?
Yeah, they all have their things that they do.
So, but the father was arrested and then but he's not still in jail, is he?
No, he's out on bail.
He's out on bail, but they were saying that they don't charge, but that the DA has to charge and that they're not recommending any charges. So has he been, he hasn't been charged.
I'm pretty sure the DA is charged. They are following through with the trial.
They are. Okay.
Which is disgusting. This dad is a hero.
Yep.
Exactly.
And the dad's bail was higher than this shitbags was after he was charged with 43 counts of essay of a child.
That's fucking crazy.
Yeah. If they never let this loser get bail, none of this would have ever happened.
Right. So
There's not a single doubt in my mind that he was going to kill her.
Yeah. Yep.
She was the only witness against him.
Damn.
Right. But so it looks like they're making an example out of the father. But how dare
Yeah, well, so I was like trying to deep dive into it. I forget who I was listening to, but the sheriff of the county where this happened, there are a ton of civil suits against him from former inmates that were complaining of SA from corrections officers.
Oh God.
And he just blatantly ignored them.
Right.
Oh, like he's dirty. He's
Yeah,
so
yeah.
dirty. He
Yep.
put a gag order on the family. He put a gag like to protect the dead guy.
Huh.
Hmm.
Terrible. Creep. And this is Florida?
No, Arkansas.
Arkansas. Oh, okay. Gotcha.
Oh, if it was Florida, we would have just the dad would be like getting a medal right now.
Right. Yeah.
Yeah.
Yeah. But you would think in Arkansas, really? Is it that like I thought that they were pretty like conservative there.
I
No?
don't know where Lawlene is. You talked to her today, Dean?
No, I talked to her yesterday, but not today.
Yeah, she was here last night. I hadn't talked to her. She didn't respond.
Yeah, Lauline.
I know she was really sick and then she was feeling a little better, but she was still like feeling it. So
Oh, I thought she was all
crashed.
better. Oh, I didn't know that she wasn't feeling well.
Yeah, maybe she's still sick. Sick of your attitude, Danny. Got him. You look dumb, Danny.
That's a big joke you've told her since
Ooh, burn.
started this channel. Can we clip that?
Look at MJ chuckle.
Does anybody know how to clip that? That was a good one, Dean.
These people, in some cases, are like.
Where'd you go last night, Dean? Did you go? You had to go to bed or something?
Hey, Laura J. Thanks for popping in to say hi.
That better something.
Laura J.
hey, Laura J.
Hey, Laura J.
Finally, Laura J's here. I told you she was coming. Told you,
She's
MJ.
been lurking. She says she lurks, and I said, all right, just check in sometimes. So we can say
We got some lurkers, that's for sure.
we love lurkers.
Heroin addicts. You know, they need to fulfill this fantasy. The heroin addict knows there's a 20% chance there's fentanyl in the heroin. They do it anyway. The predator knows there's a 20% chance they're going to get caught by me, by one of the law enforcement agencies around the country, but they do it anyway. They can't control it. And for that subset of people who commit this crime, there's no choice but to keep them locked up because they will offend again and again.
Now, to be clear, from a legal point of view, right, these are allegations that are being asserted. These are allegations being asserted by the Spencer family. But just to go back to this, according to Heather Spencer, she and her husband, they wake up at around 1 a.m. on October 8th to the sound of their daughter's dog barking, which they say was unusual. And when she wasn't in her bed, they started a frantic search. The two reportedly didn't know that Fossler had apparently been in contact with their teenage daughter. But Heather said that on social media, they believed Fossler had taken the girl to kill her. So when this car wreck happened, Spencer says he was able to grab his daughter from the car. Fossler attacked him, so he shot him. So kind of a self-defense argument. Now, the sheriff has said that they investigate every death involving a shooting like this as a homicide, and whether or not they believe that homicide was justifiable or not, that would have to be determined as the investigation progressed. But Chris, here's the thing. You put the legal aspects to the side. Whether this was self-defense or perhaps even downgraded to something like voluntary manslaughter. You're acting in the heat of the moment. You're acting under extreme emotional disturbance. Guy sees his daughter allegedly being kidnapped, and he's coming to the rescue.
Dean, you see who's here hanging out? Mary Whitcomb.
Yeah, I just said hi.
Yay.
You got the hug. Got the hugs. Yeah.
Aw, Dean got a hug too.
Oh, hugs for all.
That's right.
Nope.
Now we all
No
have.
hugs for Mary B, though.
No, I'm good.
No hugs for Mary B.
That's not true. Mary sent hugs to everyone. That includes Mary.
If you get Mary Whitcomb and a Mary B hug, you might create a vortex. You watch any movies in the 80s, Janine, when we were little?
Yeah.
You know you could. You don't want to do that.
Yeah, dangerous. Very dangerous.
Yeah, too much of a good thing.
Never cross streams.
Understand that. You put aside the legal aspect. I don't understand from a point of view, from a public policy point of view, how they charge them. I don't. I get it.
Yeah,
you don't want anybody taking justice into their own hands, but
yeah, especially given the fact that there is this belief that maybe he was going to kill the girl, and maybe in his twisted mind, without that witness, he doesn't face prison on the charges. We don't know. And we also don't know what was going through the father's head, but I can predict without fear of contradiction that the father was afraid. And if you're looking at your daughter in the hands of a predator, again, I don't see.
Done. D-O-N-E, done. That guy's going to end up in the same place no matter where he
how
was.
this guy gets charged.
Do you, let's say he does.
Yeah.
Let's say this is a murder charge. Finding a fair and impartial jury, given the community outrage here.
I don't see a prosecutor in a smaller town like this who knows everybody, who knows, all the players in this. I just can't imagine that this man will ultimately go to trial for any sort of homicide.
Now, to be clear, look, I've covered cases before, different kinds of
It's
abuse.
possible, and we've all seen,
Yeah,
exceptions to that common sense.
Yeah, because murder's not the answer. I mean, look at Gypsy Rose Blanchard. Clear case, she was abused. Menendez brothers, you can make the argument that they were abused. They're going back and forth about whether it was a self-defense argument. But the point is we're not just saying murder is a justification. But here's what's interesting. The sheriff told USA Today last week, this guy that preyed upon their daughter was released on bond, and we had stopped him that night and got him with her. That bond would have been revoked. He would have never got out of jail. None of the bond companies would have let him out. We wouldn't let him out. A lot of things there. So he's seemingly acknowledging Fossler was a predator and a danger. Let's start there.
Right.
Yeah.
So maybe what he's arguing is that the father should have called the sheriff's department, called 911, and let them handle it as opposed to take matters into his own hands. That's a good argument. And then he would have been arrested and never let out on bond again until and after he faced criminal charges in court. That's a reason why maybe you detain somebody and you investigate the case, and maybe there is some sort of charge filed, and it becomes a question of fact for a judge or jury. But in the heat of the moment, does any parent wait until the police get there? Do you call 911 and then give chase? Do you just do it because you act out of instinct? Those are hard questions to answer, and it's hard to really point a guilty finger at this dad for doing what he
Protect
did,
your
based
fucking
upon
kid,
what we know.
guy. That's not hard. Sorry, nope. Do what you need to. I'm saving my kid. I don't fucking care.
Literally the only option at that point.
Yeah, but it's kind of like a Pandora's box, though. You don't want it to be just okay to go kill pedos because they're already tricking them into
It should be okay too.
Yeah, I think I can get behind that.
Yeah.
Yeah. Nah, I don't have any issues with that. Nope. That's the lowest of the low. You don't get worse than that.
I
It
think
doesn't
they
come.
should all
They don't
go
come.
right to the death row.
We'll just get a bunch of Dexters.
Yep.
Yeah.
And they can take care of all that.
That's right.
Yeah, true.
But thank you for trying to, be the voice of reason with us.
Nice try, Danny.
Nice try. Yeah.
Pretty sus, if I do say so myself.
Good job.
I was just trying to help you losers out, but whatever. Whatever.
And it's different than, and the allegations don't support, the facts don't support this. If he had went to the car, immediately opened fire, if there was a struggle and he was trying to get his daughter back.
It would be different if this was a case where we have seen in the past where the guy somehow sneaks a gun into the courtroom and sees him and says, you so-and-so, bam, bam, bam.
Yeah.
Or if he gets him being walked into the courthouse, or he goes to his home and kicks the door in and takes vengeance that way. But this is a case where the man who was facing criminal prosecution for grooming and sexually exploiting his teenage daughter has custody of that child. I mean, I don't know. I might come unglued myself for something like that.
And just to add to this, so Heather on this post on the fundraising page wrote, "My husband is a combat veteran who has always protected his country and family. I have no doubt our child would have not come home if my husband hadn't found her." So it's a tragic case, but a complicated case and a really sad case. Again, I don't understand how you would be able to get a jury that would be fair and impartial, that wouldn't look at this and say, I can't find this guy.
Yeah, which is exactly why you have to wonder if it's even going to get prosecuted.
Yeah.
I mean, and you also have to ask the question, what are the additional charges that this guy is going to face, the predator? I mean, this obviously adds on to his he's dead.
He's dead. Yeah,
so, but so it doesn't matter now. But I mean, clearly, had he not been killed, he would have been facing a lot more time in prison.
They said they wouldn't have let him out. So look, it's a really tragic circumstance. I will say this, I can understand if they decide to charge him with either manslaughter or murder. I mean, a life was taken, I get it. But at the same time, trying to secure a conviction there, I think is going to be really, really tough.
I don't think it happens. Yeah.
Chris, so good to see you. Thanks for
Good to
coming
see
on.
you, Jesse. I
Let everybody
appreciate it.
know where they can watch you, see you,
We're
catch
on,
predators like we talk about.
We have our own streaming crime network, True Blue, TRUBLU. Watch trueblue.com for details. Takedown with Chris Hansen. We have 100 new episodes and many more on the way. Several documentaries in the works, crime related.
God, that's a lot of pedo content.
Yeah.
They're everywhere. It's disgusting.
Yep. Oh God.
I mean, that's a lot of content. Dean, explain this.
I think he fell back asleep.
No, what am I explaining?
Why there's so much pedo content on the internet.
Because there's a lot of fucking pedos, dude.
We figured that.
It seems to be a lot more common than you could imagine.
Yeah. Yeah, it is. Oof.
Yeah,
It's
Ew,
mind
right? Ew.
can't do it. Can't.
Your hair on the SUV supposedly survived a 37-mile drive in 47-mile-an-hour winds. But that little magic hair just clung there, just hung on. That same hair that moved in between photos in the Sally Port. Remember that? There were two.
Same one Roberta no, that was Wendy Murphy said yesterday in Turtle Boy's argument that was smashed into the taillight. Like, no, dummy. It's one fucking hair and it rode on the vehicle in a snowstorm, then stayed on the vehicle when the snow melted off. Like, we literally saw the snow melting off in the Sally Port, but the hair stayed on there.
The magic hair.
Not happening.
Photos taken, and it was either the breath of the photographer or just the movement of walking by the hair. It literally moved between the two photographs. But that hair is supposed to have hung on in a 37-mile drive in a blizzard. The only thing that hair proves that the Commonwealth is embarrassingly grasping at straws. That hair has nothing to do with anything. But it doesn't stop there. There was another revelation at trial, a big one, a huge one, and it came from a very unlikely source. Christina Hanley, a quiet, reserved criminalist who told you something the Commonwealth likely did not want revealed because it's devastating to their case. Absolutely devastating. And it's this. The glass on the bumper didn't match the cocktail glass. None of it. Remember, February 11th, Michael Proctor, without any other person with him, no witness, no supervisor, no other person with him, claims to have found a single piece of glass at the scene. February 11th, single piece of glass, Michael Proctor. Keep that in mind. Interestingly, the glass on the bumper that didn't match the cocktail glass, one piece did match one other thing, the Proctor glass. Those two go together. The only two things that go together from that bumper are the Proctor glass. We know that there's no glass in the taillight. We know that nothing else was shattered on the vehicle. Therefore, that glass had to be placed there. Didn't come from a crash, didn't come from a cocktail glass. So how did it get sprinkled on the back of the bumper? Whose proverbial fingerprints are on that glass on the bumper? The only thing it matched was Michael Proctor. What about the Ford Edge and that snowplow driver, Brian Loughran? He observed that Ford Edge parked outside Brian Albert's house at 3:30 a.m. That vehicle was moved directly in front of where John's body was found sometime between 2:30 and 3:30 in the morning. The only person connected to a car of that make and model, Brian Albert. Michael Proctor did nothing to investigate that point. Did nothing to investigate whose Ford Edge was parked in a spot specifically to block the line of sight in the exact position where John's body would be later found by Karen Reed. No one, not Michael Proctor or anybody else, checked it for evidence. No one even asked any questions about it. That Ford Edge, Brian Albert's Ford Edge, completely ignored. Michael Proctor failed to interview obvious witnesses in this case. Why? Why didn't he want to speak to the snowplow driver, Brian Loughran? Why did he falsely claim that no one plowed the roadway that morning? When police dash cam video, you saw the dash cam, it shows plows going back and forth all morning. Why did he wait so long, years even, to interview Heather Maxson and Ryan Nagel, individuals who were literally outside 34 Fairview at the exact same time John and Karen arrived at Brian Albert's house that night? Brian Loughran, had he...
Winks took the fucking red pill and made it into the damn Discord. So y'all say,
I tried to warn you, please.
Don't turn off the notifications. They're very important.
I
yes.
tried to warn you.
They're
Turn 'em off
hauntingly
quick.
important.
Yeah, I would turn them off very quick. Learn how to do that first. Turn off notifications. Because I might just post 3,700 memes. You never know.
Been investigated or interviewed would have told Michael Proctor that he drove past the lawn multiple times on January 29th, and there was no body on the lawn. He would have had a perfect view. Remember, the weatherman told you there was only enough snow at that time. I think he said, in a very charming phrase, only enough snow to track a cat. I think that was it. There was no body there. Heather Maxson and Ryan Nagel would have told him that they arrived at 34 Fairview shortly after Karen and John pulled up behind them, and they would have told Michael Proctor, at least Heather would have told Michael Proctor, that when she left 10 minutes later, she drove past the SUV and observed Karen Reid in the driver's side, dome light on, passenger seat empty. So where was John? Wasn't outside, wasn't sitting down, wasn't laying down. There's only one place he could be. We could all say it together if you could talk with me. He was in the house. But Michael Proctor did not want to have those answers. He did not want to have to disclose those answers. He didn't want the truth. The Commonwealth has presented a shred of evidence of when Karen Reid consumed her last drink that night. Think about that. It's critical information that the Commonwealth has to prove beyond a reasonable doubt and to a moral certainty. They have to prove when her last drink was that night. They have to prove it. We don't have to prove or disprove anything. Every single witness who was asked and who had an opportunity to observe Karen that night said the same thing. She wasn't drunk, she wasn't stumbling, she wasn't slurring her words. She was, in the words of Ms. Kolakithis, completely normal. Even Jennifer McCabe grudgingly had to admit that fact. It's on video. Instead, they used Yuri Buchanan to try to come into court and count sips of alcohol, which he admittedly got wrong. According to Ian Whiffen, the Commonwealth's own expert, the location data, using location data on John's phone, showed Karen driving lawfully. She was driving safely. She was under the speed limit. She was slowing and stopping at stop signs, slowing around corners. And Ryan Nagel corroborated that when he saw her.
Reflection I've ever seen. Hold on. Look at this. Look at the reflection.
Oh my God.
Janine thinks it's funny.
Hey, I'm off the Brandon Springfield Township Police Department.
How are you? Who's John? He's not soon.
For that warrant, and because you are suspended act. Hey. Hello. The raccoon has her meth pipe.
Look who's on there commenting.
That's my brother.
Invisible friend. I don't know what I was talking about. It's probably coming.
The cop is pointing it out to the other meth heads. This isn't good. Were these people? They're probably on it.
Look at that fucking that profile pic. Cracks me up every time.
Too. And they're getting all these animals secondhand high on meth. Oh, that's not good. Oh my goodness. Also cute top, but really with camo. Okay.
He's playing with a meth pipe right now. No, don't reach for it. That's evident.
She's like, no, I need that back. He just took my shit. Also, that's not funny, officer. Take the fucking. I mean, yeah. It overall, if you look, we're bad people. It is kind of funny, but it's also fucked up. Get the meth pipe from the raccoon. He shouldn't be touching it. Also, is that just weed sitting on top of the cigarette box? I'm not mad at that. I'm mad at this. What the fuck? Is this Fed Smoker's family? What is happening? I think this is Fed Smoker's family. Yeah, good luck getting the meth pipe from the raccoon, officer. I can't wait to see how this happens.
It's okay.
Okay, you're on tip.
Raccoons play with her meth pipe.
All right.
Oh my god.
Oh, there's no one.
All right.
Another one?
There's no way.
Shut the fuck up. Another one? Where did he get the other one? He's like, haha, psych, bitch. And he pulls out another. What the fuck? Also, did they get in a car accident? What is going on?
Come here.
Why are they outside of a mattress firm? I have so many questions. Is this Austin? Where are they? This looks like Austin.
Hello.
The raccoon has her meth pipe.
Has what?
Oh my god.
Her meth pipe. He's playing with the meth pipe right now.
Yeah, Dude, that raccoon is following Proto. They're getting feathered right now. They're getting feathered as fuck outside. Dude, they're at the Falcon car wash right now.
No, don't reach for it. That's evidence now.
Oh, I don't want him to have
Well,
that.
that's why I'm gonna do
Bitch,
it.
I don't want you to have it. Look how you look worse than a raccoon. What is going on here?
Hey, buddy.
Huh?
It's okay.
You know what? Satan thinks Jesus is going on here, and I agree. I think that's what's happening.
Okay, Your Honor. 2 beer in 2 minutes. I'm right across the mile.
Who? Who's coming in 2 minutes?
Okay.
A few minutes?
Yeah.
Okay.
This is
Why did that guy call? Who's this guy calling? Why is he fucking wasted? Who are these people? A mechanic in a jumpsuit calling for backup. A cop laughing at the raccoon with the meth pipes. Jen McCabe over here getting involved. What is going on?
what she's smoking meth in.
Okay.
The raccoon's playing with her meth
I
pipe.
don't know if this is an ad for meth or mattress firm. I can't figure it out. Mattress firm? I don't know.
All right.
He's trying
Oh
to
my
smoke
god!
it.
All right.
Yeah, he had another one. He had another one.
There's no
Fucking meth pipes. Is this raccoon the fucking deal, dude? Yes, Mandy. I was thinking Burnett Road, right north of 183. Holy shit! Where did these two come from? Where are they going? I have so many questions.
Where were they going?
All right. Enough fun and games.
Enough fun and games. The raccoon is going off to work in his meth lab, which happens to be right here. Like, is he gonna come back with? Is this raccoon is pissed? He's like, you're taking all my product.
Yeah.
This is how Gay Jeff supplies the town. This
Look at my comment right here.
Yay!
Honestly, this raccoon isn't on meth.
Good one.
I don't know any. That's for sure.
is how Gay Jeff gets his product out to the masses through the raccoons.
They all look like they're on meth.
Also, that is the creepiest.
Wait, Danny. Wait, there's a
Janine, were you here the other night when I introduced him to this video?
there's a raccoon in the back seat. Can
Oh, I
we
know that's
watch-
the end of the video for hers though.
Oh.
Got a full video to get the second.
Oh,
part,
this
the
one.
extra raccoons hiding out in the back of the truck.
Oh
You seen this? Were you here the other night, Janine, when we played this?
Yes.
Oh, good.
You wouldn't believe how the fuck it makes you feel.
Yeah, but you're a beautiful
This
woman.
man-
You don't need that stuff.
Hey,
Okay? You don't need it. And
Oh, guess what?
Mhm.
Saturday night is the last of it. We're quitting.
no, you're making up stuff. Stop lying. You're not telling the truth.
I'm gonna
No,
go
you're not telling the truth.
gonna
Now.
go-
You're not gonna stop. How long you been doing it?
6 years. That's all.
You sure?
And I was a year and a half of that. I was straight.
You're only 28.
all 6 years, that's all.
You sure?
Mm-hmm.
You're only 28.
You said $18. You don't need to go buy nothing but something to eat. Okay?
Okay.
All
Yeah,
right.
This will get me a sausage and egg biscuit. Well, if I had like 50 more cents, which I can get.
Yeah, that's $20. You don't need no 50 more cents.
Do
You
you?
don't go buy no crack. The-
Oh,
Why you do
Christ.
that? Jesus.
Oh, okay. I got to refund it.
crack.
Aw.
The-
Oh
You have a good day, okay?
It makes me feel so fucking fantastic and
And,
so horny.
Oh Lord. Okay, you have a good.
Here we go. Did it go all the way downhill right here?
Okay. Yeah.
It makes me want a thing in my mouth.
No, don't.
Oh God. Poor lady. Jesus Christ.
What is that?
Yeah.
Oh, lady,
Missed
I'm
that.
It makes me feel so fantastic and
And,
so horny.
Oh Lord. Okay, you have a good day, okay?
Hold on, my wife's going back upstairs. I'm gonna wait for her so she can watch it.
Oh, okay.
10 seconds. 10 seconds.
Yep.
10 seconds.
It makes me feel so fucking fantastic and
And,
so horny.
Oh Lord. Okay, you have a good.
Here we go. Okay, here we go. This is the part of the slide where you build up the most speed.
Yeah, okay. Yeah.
It makes me want a thing in my mouth.
No, don't.
I'd
You
be
have a
like,
good day.
put
Okay?
it in
No,
my
no,
mouth,
no,
in my motherfucking mouth.
no. Look, go get you something to eat. Bye. You have a good day. Okay?
Bless
All right,
It's great
Lionel,
meeting
you
you.
want me to
No, ma'am.
pay
You
it
don't.
back in my mouth?
anything.
Go,
But you go eat.
look, go get you something to eat. Bye.
I'd
You
be
have a
like,
good day.
put
Okay?
it in
No,
my
no,
mouth,
no.
in my motherfucking mouth.
Ay, 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 Dios mío.
Hey, what
Ooh.
people? Why do people exist?
And now back to this.
Oh, poor
this
lady.
is my.
We're praying for you, lady.
Had incredibly high burden to prove Karen was driving under the influence. They have failed to prove that beyond a reasonable doubt and to a moral certainty because it depends on when she had her last drink. What happened after she got home and she was upset with John for not coming back out of the house? That would answer that question. As you well know, no one searched the house for signs of a struggle. Not that night, not the next day. I'm talking about 34 Fairview. Not ever, not once. Not with a warrant, not with consent. They never went into the basement, the stairwells. They didn't look at the walls. They didn't look in the garage. Nothing was ever examined. Nothing was checked for blood. Nothing was checked for DNA. They didn't look for alleged or ridged surface. Zero. You'll remember how surprised Jennifer McCabe was to recall that there was a garage door even on the house, except this was her sister's house. She's been going to that house since she was 5. She's seen that house. She's been in and out of that house hundreds of times, maybe thousands of times. She's been going to that house her entire life, and yet she acted surprised.
Okay. Sorry. I got to interrupt this again.
About the ride. It was great. And apparently, I've never been on live television before, but apparently sometimes I don't watch I don't watch the news because I'm a kid, and apparently every time Grandpa just gives me a remote after we watch the Powerball.
When I asked her about it, the answer, when I asked her
We should be watching the Powerball.
Powerball, apparently.
No. No. You can no. No, he's sleeping.
Rodent.
And the garage door, and her answer was, oh, actually there is a garage door right there. Investigators never opened that door. Let's change the scenario. What if it wasn't the house of a Boston cop? What if it wasn't the house of Brian Albert? We can be certain that investigators would have torn that house apart to get answers about why a fellow police officer was laying dead on the homeowner's lawn. You can betcha. But because this was Brian Albert's house, a Boston cop, nope. And because he was a fellow cop, an insider, they didn't even open the door. That is not justice, folks. That's just pure favoritism. Each of these facts is more than a question mark. They're failures of duty. They're blank spots on a map where justice is supposed to live. And every single one is a reason why you cannot convict Karen Reid. Reasonable doubt abounds. If the Commonwealth failed to investigate every reasonable alternative, how dare they come in here?
I'm poor.
Aww.
They didn't investigate the case fully, and yet they're asking you to take the easy road and do their job for them. These facts do not represent reasonable doubt. Nothing does. Every one of these facts that you're seeing that we're talking about represents reasonable doubt. Everyone. The police and the prosecution are in a position to take people's liberty. It's the most dire and consequential act a civilized government can take against one of its citizens. Their obligation is not just to try to get it right. They have to convince you to the highest degree of certainty known in human affairs. They have to do it all, every bit of it, beyond any and all reasonable doubt. And they have not done that here. And how about the homeowner himself? The host, the first responder, the Boston cop, Brian Albert, who was sparring and practice fighting with Brian Higgins just minutes before John O'Keefe appeared at his house, 34 Fairview. Brian Albert, who was watching Chloe that night, the German Shepherd. Brian Albert, whose phone and his wife's phone were never secured. Brian Albert, who never came out of the house. But that doesn't mean he wasn't awake. It doesn't mean that he wasn't on his phone. Think about this. Jennifer McCabe claimed that her sister and Brian Albert both slept through this complete chaos right outside their bedroom window. But Jennifer McCabe's phone records tell a different story, and they tell the truth. She spoke with him for the better part of a minute, 38 seconds to be detailed about it, at 5:07 a.m. And then she lied about that call. Remember that? What was the reason for that call at 5:07? Was it panic? Was it a warning? We know that conversation took place at the precise time Karen left her house to go search for John, 5:07. We could answer those questions if we just had access to their phones. Brian Albert, Brian Higgins, but Michael Proctor wasn't interested in their phones. Not only did he not secure their phones, he never even asked. And what about Brian Albert's dog, Chloe? A dog with a history, a dog that is, quote, not good with strangers. Dr. Russell confirmed that John's patterned injuries were from a dog, just like the dog Brian Albert owned. And then Chloe just disappeared. Not there the next morning. None of the officers that you heard from said that there was a dog in the house. They didn't see her. She was just gone. And then ultimately gotten rid of altogether. Who gets rid of their family pet? Unless they had something to hide. Michael Proctor wasn't interested in that either. And recall the group chat with the Alberts and the McCabes. They were getting their story straight. Matt McCabe, whom the Commonwealth did not call in this trial, instructed the group in that group chat, you'll recall, tell him to say the guy never came in the house. Think about that exact quote. Tell him to say the guy never came in the house. And Brian Albert, the patriarch of the family, exactly, exclamation point. He blessed it. With the truth, as we all know, you don't need to get your story straight. You don't need to tell someone what to say. It's just the truth. And what about the Google search? A Google search that Jennifer McCabe admitted having made. A Google search that was timestamped by Celebrite at 2:27 a.m. A Google search that read, Hoslong to die in cold. It is uncontested and undisputed that that search was deleted. If the 2:27 a.m. timestamp is not true, why does Jennifer McCabe have to lie about it? Why delete it? If the 2:27 a.m. timestamp is not true, why create a false story about Karen screaming Google hypothermia? That's just a fabrication. That's just a made-up fact. And by the way, if someone does tell you Google hypothermia, why would you Google how long it takes to die in cold? Wouldn't you just Google hypothermia? Jennifer McCabe enlisted Carrie Roberts to help shift the blame to Karen. Why go to that much effort unless you're trying to cover for something? Keep in mind the entire foundation of her claim that Karen said Google hypothermia is this fantasy about Karen screaming it at the location, at the scene. That's her entire excuse. But that story went completely off the rails when Carrie Roberts admitted that she perjured herself to back up Jennifer McCabe's false story. That was a dramatic moment in court. It's an admission of perjury, and you don't see that very often in a courtroom. That tells you everything you need to know about the character and quality of the prosecution's case and their witnesses, lying and perjury and admitting to it. A fundamental tenet of any investigation is to ensure that witnesses are independent and not influenced by other witnesses. You start by separating the witnesses. Michael Proctor did none of that in this case, and we see the results. Think back to Jennifer McCabe's own text messages with Carrie Roberts. About Carrie Roberts, not with Carrie Roberts, notably. What Carrie Roberts didn't know was at the time she was being interviewed by the police, Jennifer McCabe was in real time. She was bragging about having influenced Carrie's testimony or her statements to the Alberts and the McCabes. Quote, she's telling them everything, all the stuff. Remember that timeline that we talked about with Jennifer McCabe? That's what she was referring to. She's telling him everything that Jennifer McCabe had put in Carrie Roberts' timeline. The Commonwealth wants you to believe that Karen Reid made a statement at the location, at the scene. I hit him. I'm sure you'll hear that from the prosecution in their final arguments. But their own witnesses contradict that. Jennifer McCabe admitted on cross-examination that her very first statement to law enforcement, confirmed that Karen didn't say anything. She asked, could I have hit him? Did I hit him? Is he dead? The physics and the science answer that question. Could you have hit him? No, you couldn't have. Sergeant Buchanan also testified that the only statements Karen Reid made at the scene, according to his conversations with the first responders, was, could I have hit him? Did I hit him? It wasn't a confession. It was confusion. And Dr. Russell explained that confusion. She told you why Karen Reid, or anybody in that position might ask those questions. She was suffering from extreme grief reaction, which according to the evidence can last for years. Even her medical records confirm that diagnosis. It's common to ask those questions in grief. It's common to ask those types of questions in shock. You're trying to make sense out of the nonsensical in the moment. And the Commonwealth has tried to twist those words into a confession. There is no evidence that any officer at the scene ever heard Karen Reid say, "I hit him." Not a single police officer at the scene came in to support the Commonwealth's claim. It's not on video, it's not on audio, it's not in a single police report, it's not in a single EMT or EMS report. Nowhere. The fact is, Karen never said, "I hit him." You saw the video, multiple officers were right there. She simply never said it. What did Jennifer McCabe do and not do when she got to 34 Fairview? She would have you believe, I want to set the scene for you, that she's confronted out of the blue with John O'Keefe's lifeless body. Her friend, John O'Keefe. He's bruised and battered, he's bleeding, his eyelid is cut, his nose is bleeding. Karen is screaming at the top of her lungs. Carrie is screaming back to Karen, "Shut up!" Both women begin crying. Both women are giving CPR. There's chaos everywhere. It's building in the yard, just feet from Brian Albert's house, Brian Albert's window. Jennifer calls her sister at 6:07 with all this chaos going on. No answer. Jennifer calls her sister at 6:08 with all this chaos and bedlam going on. Still no answer. No lights come on in the house. In the midst of all this screaming and this chaos, Brian Albert doesn't come outside. Nicole Albert doesn't come outside during this maelstrom. And yet, Jennifer McCabe never goes inside to check on her sister. There's literally no signs of life inside the house. And Jennifer McCabe doesn't take a step inside that house to check on her family. Why is that? Does that make any sense? Everyone would sprint inside the house to make sure that there's no one in there that was hurt or injured or, God forbid, dead. Everyone would do that. But not Jennifer McCabe. The only way that makes sense is if Jennifer McCabe already knew that Brian and Nicole were just fine. That's the only reasonable explanation. And the only way she would know that they were fine is if she knew what happened. But Michael Proctor never explored this incredibly suspicious behavior. Don't you have questions? This would give anyone reasonable doubt. And don't you have questions also about Brian Higgins? Michael Proctor certainly didn't. Higgins had been sending flirtatious and romantic texts to John's girlfriend, Karen Reid. You'll remember I asked Sergeant Buchanan a simple question. Were those texts flirtatious in nature? He refused to answer that simple question. Do you remember that? Quote, "I'm not comfortable putting a label on that," end quote. We read the texts. It's not a secret. Of course they were flirtatious. Of course they were romantic in nature. The reason he refused to answer that simple question is telling. It's because these flirtatious texts establish a motive for Brian Higgins. Sergeant Buchanan could not bring himself to tell the truth. His bias was on full display. He was covering for another cop. Investigators also ignored Higgins' suspicious late-night visit to the Canton Police Department. That was after a night of drinking, by the way. Why didn't they investigate this? What was so important that Higgins needed to go to the police station at that time, 1:30 in the morning, while drunk, by the way? Why weren't they interested in those facts? Remember, he's an ATF agent. He's a cop, a member of the Blue Wall, and best friends with Brian Albert. He would know that the CPD would be the first to get the call when someone reported John missing or injured. He would know what to look for, what to listen for, to determine if a report had been made and when and what the response was going to be. You saw the skulking through the hallways with his hood up, moving bags between cars, and of course, that late night mysterious phone call on his cell phone, a phone that you don't have and that you'll never see. All of that, and Michael Proctor never gave him a second look. All of that, and the Commonwealth, who's supposed to be after the truth, didn't call him to the stand. If you have any unanswered questions about Brian Higgins, that's reasonable doubt. The police didn't interview Brian Higgins on January 29th, 2022, but he was at the police station, as we've just seen. You heard evidence that Higgins and Chief of Police Kenny Berkowitz, also good friends, were in the Sally Port together with the SUV for a, quote, wildly long time. Kelly Dever, another Boston cop, told you that. She also told law enforcement agents that she found it, quote, weird that Higgins could have access to that very sensitive evidence, the SUV. Folks, there is never a situation in which a witness, a potential suspect even, should be given access to the evidence in a case. But that's exactly what happened here. Higgins was given unfettered access to that SUV and its taillight nearly immediately, according to Kelly Devers' statement to law enforcement. And it was at that exact time, the exact moment that Higgins would be at that Sallyport, that the 42 minutes of the Sallyport video is just missing, just gone, vanished. Well, that's convenient. Now put in context the condition of that taillight when it was actually seized in Dighton. It was cracked, but not completely damaged. I ask you to compare and contrast Officer Kelly Dever, her attitude, her demeanor. That's all for you to judge. Her attitude, her demeanor, her truthfulness, her motives from the witness stand. Compare and contrast that to Sergeant Nick Barrows. Who's more believable? Officer Barrows is unattached to any of the players in this grand play directed by Michael Proctor. He's truly independent. And what did he tell you? Was the taillight, he was asked, was the taillight in this condition when Michael Proctor picked up that SUV at 412? His answer? Absolutely not. Absolutely not. It was cracked, but not completely damaged, not smashed out like that. So how did the taillight get cracked? How did it end up in the condition where it was cracked, as Officer Barrows saw it, but not completely damaged? Well, you don't have to guess. There's a video. Just watch. That's how it got cracked. And Judson Welcher's own recreation confirms it. Look at the contact. That's from the Commonwealth's expert. And that further is confirmed by the fact that there were no taillight pieces found in any of the initial searches conducted at the scene. 2 searches, 50-foot area searched. Not a single fragment was found until after Michael Proctor had access to and control of that SUV and its taillight. What does that say about the character and quality of this case? It's revealing what happened here at trial. One of the most dramatic moments probably of the trial, Kelly Dever. How can you trust this investigation when you saw how far a police officer will go? You had a front row seat to the power of police manipulation and police corruption, a front row seat. Kelly Dever was interviewed by a separate law enforcement agency, not a friendly department, not Boston Police Department, not Michael Proctor's MSP, a different independent agency. She told those law enforcement agents in a formal interview that she saw Brian Higgins and Chief Kenneth Berkowitz alone in the Sallyport with the SUV. She was detailed, she was clear, she was unequivocal, she remembered the specifics, she recalled how it made her feel, quote, weird. She recalled that how long Higgins spent, a quote, wildly long time, as she described. These are all incredible details to tell law enforcement. She couldn't have been clearer, she couldn't have been more specific. But then she's put on a witness list and she's subpoenaed by the defense. Oh boy. Then this rookie cop was called up to the police commissioner's office, the same commissioner that was the boss of Brian Albert. They have a meeting, a private meeting, and he says, wink, wink, nod, nod, we support you, Officer Dever. What else was said in that meeting? What else is reasonable to believe was said in that meeting? She claimed she couldn't remember. She claimed not to remember if he instructed her to do the right thing. But the commissioner of the Boston Police Department certainly said something to this rookie cop, and all of a sudden, that detailed, unambiguous, unequivocal statement to law enforcement became, what did she say? A false memory. Not I didn't say it. She admitted she said it. She admitted she detailed the entire story. She just said, it's a false memory. What? So she's called to the commissioner's office to make sure that she would do the right thing. That's why she was called. And now we know what that means. In her words, my entire career depends on what I say here on the stand. I'll quote that again. Quote, my entire career depends on what I say here on the stand. You bet it does. That's how it works. And that's how we got here. At the end of the day, you have to ask yourself, can you trust the Commonwealth's case? Can you trust their witnesses? Can you trust their evidence? And here are a few of the highlights. A video that was played in a courtroom and sold as accurate. Turns out it was completely inverted, flipped backward, completely false. The test that formed the basis of their entire theory of the case. Watch closely as Dr. Welcher stands as a surrogate. Is that a righteous test, or is that a manipulation? Dr. Welcher tried to deceive and fool you by leaning into the car, manipulating the results of his own test When the truth was revealed by Dr. Rentschler, the Commonwealth spent the next hour cross-examining him about how that test was meaningless. It actually didn't mean anything. Well, that's convenient now that we realize that it was a manipulated test, and it actually does mean nothing. It didn't represent the theory of the Commonwealth's case. That's what was suggested. That test does not represent the theory of the Commonwealth's case. Really? Then why was Dr. Welcher playing dress up in John O'Keefe's clothes, or identical clothes to John O'Keefe, when he was holding a glass? Why was he holding the glass right behind the vehicle? And why was he standing with his right arm oriented to the right rear tail light if he wasn't trying to recreate the circumstance that is the Commonwealth's entire theory? The Commonwealth stood up here with a straight face and told you they weren't trying to suggest that that's how John was hit by the car. Of course they were trying to suggest that's their theory of the case. They only abandoned it 2 days ago when it was revealed by our experts that it's physically impossible. That silent witness, that science, that physics has become very pesky to the Commonwealth because there was no collision. Dr. Welcher also told you under oath that there were no x-rays taken of John's arm. He tried to deceive you into believing that John's arm might have been broken. I don't know. I didn't see any x-rays, so I can't tell you what the damage was inside the arm. Really? The Commonwealth has had those x-rays in their possession for 3 years. And again, it took the defense to bring out the truth. The x-rays do not fit the Commonwealth's theory, so you weren't shown. And Dr. Welcher wasn't going to admit it. And my goodness, then we get to the sweatshirt. That was a moment. Mr. Brennan stood here in front of you and dramatically held up John's sweatshirt, not just to the witness, but to you, and asked Dr. Wolf about it multiple times. Specifically, while it was in that plexiglass, asked Dr. Wolf about the multiple holes in the back of the sweatshirt. He interrupted Dr. Wolf, and Dr. Wolf started to look at the sweatshirt and say, well, and he said, how about here? Here's a hole, here's a hole, here's a hole, here's a hole, dramatically tapping on that plexiglass. It was clear what the suggestion was, that the holes in the back of John's sweatshirt were from January 29th. That's the impression that was expected to be left with you. That's the impression that he wanted to leave with you. And that's false. The truth is, the Commonwealth created those holes. They aren't holes from road rash. They weren't made on January 29th. Those are cuttings from the Commonwealth's own crime lab, folks. That's what those holes are. And even with 3 prosecutors, all 3 of them, sitting right there in the room at the time, it had to be the defense to correct that record, to bring out the truth. If we hadn't done that, what impression would you folks have been left with? That's more than negligence. That's dangerous. It's dangerous. I'm going to guess that Mr. Brennan's not going to say much about this, about the fraud that was attempted on you. And if he doesn't, that speaks louder than any concocted excuse that the Commonwealth might come up with. It's shameful. It's shameful. We are after the truth in this courtroom. You're entitled to it. Demand it. Why would the Commonwealth stoop to a stunt like that? It's desperation. They know what you now know, what their experts know. There was no collision. So now we've reached the final moments of the trial, and you've seen the facts and you've seen the evidence, and we've just talked about dozens and dozens and dozens of facts that are reasonable doubt. Each one of them are reasonable doubts. These facts, these note cards that you're looking at, piled high, one on top of another, literally stacks and stacks of them covering the table. As you mentally sift through those cards, realize that every one of them is a massive hole in the Commonwealth's case. Every single one of the note cards represents a hole in the Commonwealth's case. If you're holding mentally even one of those cards, you're holding reasonable doubt, folks. You're holding a not guilty verdict. Reasonable doubt is not a sliding scale. It's a wall. If the Commonwealth cannot get over every one of these dozens of walls, you have to acquit Karen Reid. The truth is, Karen Reid is not guilty. Not because of technicalities, but because the facts, the law, the science, the physics, the data, they all say so. They demand it. The Commonwealth does not have a theory about how John was hit by the car. They haven't even shown you that it's possible that he was hit by a car. And the reason they haven't is because it's not possible that he was hit by a car. There was no collision. Your job is not to do their job, their burden entirely. It's theirs. They have to prove this case and their theory beyond all reasonable doubt and to a moral certainty. And not only do they not have a theory, they can't prove one that doesn't exist. all you need to know is that the Commonwealth failed. They failed to provide you with a truthful representation. They failed to prove the essence of their case, that John was even hit by a car to begin with. They failed to prove any intent on the part of Karen Reid because she has none. They failed to investigate the actual suspects in this case. They failed to present the lead investigator to you. They failed to justify the perjured testimony that you heard discussed in this case. They failed to hold accountable an officer who came in here and lied to you and claimed false memories so she could do the right thing to cover for a fellow cop or cops. They failed to maintain a fair and unbiased and honest investigation. They failed to present you with the truth. And this is what you get. An investigation that's riddled with errors and omissions and a rush to judgment and conflicted and corrupted from the start. Every part of it. That is the literal definition of reasonable doubt. How can they ask you?
MJ, you talking all that smack. This is me and you right here. This is me on the right.
That's exactly how it's going to go down.
This evidence. When the government fails so completely, so catastrophically, when there are dozens and dozens of points of reasonable doubt on the table, your duty, your oath is clear. Your sworn obligation under the law is to acquit Karen Reid, not just because you can, because you must. Justice demands it. Do not let the Commonwealth get away with this. Don't let them get away with this. Do not endorse and sanction an investigation that is broken and corrupted top to bottom. But just as importantly, do not let Michael Proctor get away with it. And make no mistake about it.
No, MJ. This is you. And that's me on the right.
Oh, Danny, you're not the big blonde guy on the left.
You convict Karen Reid of anything. If you convict her of anything, science, the physics, the data, they lose. But tragically, Michael Proctor wins. Remember his texts. Something stinks. Yeah, but serious charges will be brought on the girl. She's fucked. Could you ever say to yourself, this is justice? The fact is there was no collision. A car did not kill John O'Keefe. So I ask you, let your voice be heard, not in whispers, but in truth. Let the community feel through your verdict that justice cannot be bent and that it will not be buried. Find Karen Reid not guilty, not guilty, not guilty. Thank you.
Bam.
Oh, man. Whew.
That is the man right there.
Yep. Fire.
That was a good dose of Alan Jackson.
He's pure fire.
Mm-hmm.
Love that
Good
guy.
dose of Alan Jackson.
I'm sorry, did you say something?
I said that was a good dose of Alan Jackson right there.
Yep.
Yeah. Yeah.
Good little dosage.
Got my fix.
Yep. Some A vitamins.
Well, we got Mary Whitcomb in the right Discord now.
Nice.
Ah, nice. I look forward to seeing her. Very
Yeah.
good.
That was fun.
That was. Thank you, brother. Thank you, Mary B.
Yeah.
Thanks, chat.
Say goodbye to everybody. Hold on. Nope.
Girl,
Bye,
my
buddy.
Good night, everyone. Angel, Toy.
Which outro do we want?
Jay.
Let's do the rats.
Well, yeah, they're all rats now.
Who
Oh, they are? I don't know.
Do the good one so we can hear it.
Everybody else is sleeping.
All right. Whatever you pick, I'm sure will be perfect.
Let's don't wake everybody up now.
Okay.
Oh, yeah. Welcome to the Rat House, baby. Where the truth ain't quiet, and neither are you. We're the CHATRATS crew, slide in, pull up a seat, crime talk, cold facts, and a jazzy backbeat. We got stories to tell, got some justice to serve, so pour up that coffee or something with a swerve. There's Rat Daddy leading 6'5", a cool Toys the queen with the sharpest of tools. Dean's cracking jokes, Mary B's got the tea, and Lawleen lays the law down, real boss energy. MJ's got the fire, Gingy's taking names, Chelsea's dropping Angel Baby's in the game. The clerk's keeping order, Misty's watching close. Pinky promises, keeps receipts, and she does the most. We're the CHATRATS, baby, worldwide and bold. Stories unfold while the crime scene gets cold. Puff, puff, pass, and the truth gets exposed. At the Rat House, baby, that's how it goes. Snap, snap. Cherry lights it up. Cherry lights it up, neon glow behind her head. Tombstones drops the facts that awake the dead. Connor's taking notes, Janine's on the clock. Petty the paralegal keeps the court on lock. Sweet woman, sweet, but she'll sting if you like. Calypso keeps it cool, got that island vibe. Prince Lover's in purple, that Texas pride glowing. Sherry's laughing loud while the facts keep flowing. Bum, 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 bum. Da-da-dum, da-da-dum, ghetto. OG coming through, crazy-eyed cheese, oh you better believe. Robo-Rat clicks, sparks, gears in his head, breaking the code till the lies drop dead. Jump, we're the CHATRATS, baby, worldwide and bold. Stories unfold while the crime scene gets cold. Puff, puff, pass, and the truth gets exposed. At the Rat House, baby, that's how it goes. Rat solving, cracks. Worlds are stage. That's a fact. Together, we're the CHATRATS crew. We ain't looking back.